Well, I cannot complain. Mm-hmm.
Judge. Number.
Yes. Let me invite you. Let me invite you, but I think Deputy Laura has it.
What happened to the computer?
I don't know. They did something to it.
No, that died.
Yeah.
It's not on. Oh, I turned it off. Who turned it off?
It wasn't me.
Who was it? Not me.
Vashon, did you get it?
Yes.
Uh-huh.
Thank you.
You're welcome.
You messed around with this again.
All right, everyone. It is 9 a.m. Good morning. It's going to be a great day today because tomorrow is Friday. All right. Does somebody need to help her with the boxes? I'm going to call the docket. If you're here, you need to let me know you are here. If you don't answer the docket, I'm going to assume you're not here and a warrant may be issued for your arrest. Please stand when your name is called. In custody, we have William Condra, Antonio Davila, Eric Orta, Marcus Lewis, Kevin Law. Okay. All right. Thank you. Kevin Lawwill. Kevin Lawwill. Dimitri Gomez. Dimitri Gomez. Jesse Hinaho or Inaho. Thank you. Robert Chevalier. Hannah Smith is in custody. Julian or Julian Hughes. Julian Hughes. Josara Perez. Thank you. Sharona Williams. Raul Reyes. In custody is Manuel Dello. Robbie Gonzalez. Thank you. Mr. Smith, you're taking up a lot of the docket.
I know, and I have to go to the 379 for a jury trial. Was picking back up.
Okay, just give me one moment. Alex Arazola. Alex Arazola. Ryan Halton.
He's here with counsel, Your Honor.
Thank you.
And
Marquise Beausier. Marquise Beausier. In custody is Jonathan Tate, Sky Anthony Daniels, April Polinar. Cruz Rivas is in custody, Armando Jimenez, Brandon Juarez, Alfonso Rodriguez.
In custody, Judge.
Thank you. Jeremiah Hall. Valerie Castillo. Antoine Lynn is in custody. Jennifer Tagle. Megan McCloskey. Thank you. Chelsea Warren. Gregory Gonzalez.
President, Your Honor.
Starlin Rodriguez. Assam Wilson. In custody is Clinton Johnson, Stevie Stokes, Genesis. Thank you. The double L still get me. Mark Lewis is in custody. Cruz Rivas, Devon Ramirez, Mariah Lopez, Joshua Gonzalez, Andy Maldonado, Pierce Jones, Juan Carranza, Sergio Garcia, Antonio Flores, Nathan Chavez, Victor Mendoza are in custody. Alex Martinez, custody. Domingo Flores, custody. Yvette Hernandez. Christopher Lemire.
Your Honor, he's supposed to join via Zoom.
All right, thank you. Mike Marino is in custody. Jason Hickman, Montoya Callahan, Valencia Robello, Adrian Arias are in custody. Arturo Vara.
Morning, Judge, she's present.
Thank you. In custody is William Webster, Sherry Cooper, Jonathan Aguilar, Joshua Hernandez, Jonathan Ramirez, Richard Gonzalez.
He is in custody, Judge.
Okay, thank you. Christopher Ritchie. All right, is there anyone who came in late or your name was not called? Yes. All right, have a seat on the front row. Anyone else? All right, these are the rules of the court. I try to keep the center of the courtroom as least congested as possible. Attorneys, the prosecutors have the boxes of file. Just grab whatever your client's file is, grab it, put it on the prosecutor's desk, have a seat. They will call you when you're ready to confer. When you want to approach the court, do not approach unless you've spoken to your client, you've spoken to the prosecutor, and you conferred. And the state, if they're able to give an offer, make sure you give that to your client. If you have somebody in custody, you need to let the deputies know. They will bring them out. Do not approach the court if you have a client who's in custody and they have not been brought out of the box. And Mr. Smith, you're the only exception to that rule because I know you have jury trial. So once you are ready to approach the court, just grab the file from the court, have a seat. They'll put it here. We'll go first in order of appearance. Please do not stand and stare me down, waiting for me to call you, because I guarantee you what I'm doing is I'm signing other documents that I have here, but I will call you and try to get you out of here as quickly as possible. Today is Thursday. We are closer to Friday than we have ever been this week. So everyone put some patience in your pocket. It's going to be a great day, and confer. All right, Mr. Smith.
Three clients, Mr. Lewis is in custody.
All right, let's start with Josiah Pierce.
He is present.
All right, if you'll come forward. Oh, and you don't need to bring up Deputy Laura, Mr. Smith's clients, you don't need to bring them up. But I'm going to give you dates to give to them. All right, so I have this last set in here was for disposition. What is happening?
We're still proceeding with trial.
All right, so Ms. Paris, your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without cause. Do you understand? All right, let me explain to you what that means. That means if your attorney negotiates with the state now and the state gives you an offer and you decide to accept it, the only way the court will accept that is for good cause. So there has to be a good reason for me extending your plea deadline date. Do you understand? All right. So we're going to reset this. We're coming back on October 31st. All right, so let me give you a reset form. All right, you'll need to sign that, and that's your jury trial date. Brenda, do you see what page Paris is on?
Page 5, it's kind of
All right, thank you.
spelled.
Thank you. All right, your next person is Robbie Gonzalez. All right, my understanding that all discovery has been received. State on Robbie Gonzalez. I'm going to need an acknowledgement of discovery to be done on that case. And Mr. Smith has to go to jury trial. So if you'll make sure that that's just ready for him to sign, and you can come back over during any time you have break, Mr. Smith. All right, this case was supposed to be for disposition today.
Yeah, sure.
So is he going to proceed with the plea?
We're going to proceed with trial here.
All right. Was an offer tendered to you?
Yes.
All right, Mr. Gonzalez, are you accepting the state's offer or rejecting it? All right, Mr. Gonzalez, I'm going to ask you a question. I mean, no disrespect by asking it. If you're drug tested today, is everything going to be kosher?
Yeah, I'm just on some new psychiatric medications.
Okay.
To try to find what the best concoction.
Oh, they're trying to get the best.
And it's making me
Combination?
a little drowsy. I've never taken it before.
Be sure to if you have side effects from it, be sure to let your doctor know, okay?
Every medication has side effects. So all my medications have some form of side effect.
Yeah.
It makes it healthier for my mind.
Okay. All right, but be sure to still keep in contact with your doctor and let them know, okay?
Yes, ma'am, of course.
I always tell people, don't keep your side effects hidden, let the
Yeah.
doctor know, because there may be some other different medication.
I can tell when I'm feeling off all the time.
So are you feeling off now or no?
Amen.
Okay. So- What I'm going to do is I'm going to recall his case for October 31st, because I want to make sure that all the medications are where they need to be. And October 31st is just going to be your court date. It's not a trial date, okay? And if you need anything else, Mr. Gonzalez, just let your attorney know and he can let the court know, okay? And thanks for dressing appropriately for court. I appreciate it. And Mr. Smith, is there going to be a need for a competency evaluation on this?
Not at this time.
Well, I mean, people say not at this time, but I don't want us to be scheduled for jury trial, then it's at this time.
I believe that it would be in the best interest, just in case,
Okay.
that there are a couple deeper issues. Perhaps I could come by Monday.
Well, let me ask you this. Do you want the court to order it or do you want to order it yourself?
I think, I don't mind the court ordering it if we can do both.
All right, I'll make sure that we order it.
Thanks.
All right, Mr. Gonzalez, because you're on bond, when the evaluation is ordered, you're going to need to be in contact with your attorney so they can set up an appointment time for you to speak to a doctor, okay?
Yes.
All right, thank you so much. Hmm?
Yeah, she's ready to do it. Are you ready on this?
Yes.
Did you? No, fantastic. If something comes out, let me know. Yeah.
I made a wrong call.
Where did you get?
Thank you.
All right, and Mr. Smith, Mark Lewis. And Brenda, what page is Mark Lewis on?
I think that was just a point here. I don't think that's an old case, if I remember correctly.
Well, his plea deadline date is also set on October 14th, but we saw that you were in jury trial. Oh, actually, it's an MTR.
No, wait, that's.
Oh, that's Marcus Lewis. I'm looking for Mark Lewis. All right, is Mr. Lewis in custody?
Yes, he-
All right, so what we're going to do on Lewis, we're going to bring him back on the 31st as well.
very well.
All right, do you have anyone else with us?
No, Your Honor.
All right, you're excused.
Thank you.
Page. All right, thank you. Okay. Okay, all right, Julie. Okay, do you need anything? Okay. All right.
Just this person's not on the property. Based on the email that you sent me, he said, "Oh, you wanted to see it." He was actually somewhere else. So they told him that, I just got to get it. He wanted to see this. His lawyer will be present, and then Mr. Lemire is an elation.
Okay, all right, thank you. I need to see the file on Christopher Lemire. Yes.
I move it. I don't need the client. I've got most street side evaluation.
What's the name?
Relax, please.
Who drew this?
Yeah.
Want to make sure.
All right, Ms. Abrams. Okay, on this case, is this a motion to revoke or no?
Which one is that one?
Lemire.
It's not a motion to revoke. It was an email sent from
Okay.
the CSO in regards to the GPS. The email just states that basically the officer just wants the GPS.
Okay, everyone needs to have a seat. Don't congest the center of the aisle. Just get the file from the clerk and have a seat, and I will take you up in order of appearance.
The CSO just wants the GPS to be reinstalled. And you were saying that there was possibly issues in the past with him charging the device, so you wanted to.
Thank you. All right, Mr. Lemire?
Yes, ma'am.
All right, so there have been some issues because you're on GPS and you need to make sure that is charged. Do you have a book or something where you can write your schedule down?
Yes.
All right, so what you need to start doing then to help you out is on your journal or whatever you have or whatever calendar you have, you need to just put a notation in there saying need to recharge. You understand? And there's no harm in that. I have a calendar for everything I do, so I'll know where I need to be and when I need to be there, okay?
Okay.
Because we can't have you to continue have GPS and it not be charged, because if it's not charged, we don't know what's happening. You understand?
Yes, ma'am.
All right, so keep it charged.
We just need a directive to, be sent for them to reinstall.
Okay, so the GPS is going to be reinstalled, okay?
What does that mean?
Well, let me ask you this. Do you still have GPS on?
Yes.
All right, so what's going to end up happening? It's just going to, we're going to make sure that it's working properly, okay?
Okay.
All right, thank you. Thanks for coming in. Probation will be in contact with you, and make sure you keep your journal. And in that journal, you need to write down the times you need to charge it. And just put, you know, if it needs to be charged every day at 10 p.m., put in there, charge at 10 p.m. You understand?
Yes, ma'am.
All right, do you have any questions about anything?
No, are we finished?
We are finished.
Good.
All right, bye-bye.
Bye.
Over to this room. Yeah, or reinstate. Thank you, Your Honor.
All right, thanks. And probation on Mr. Lemire, can you make sure that you all continue to get the updates from the facility where he's placed? I don't want us to lose track of him. Who's here on Julianne Hughes?
Morning.
Good morning. It says here your client is to appear in County Court 12 first.
Well, let me explain what happened. That was at our last setting, County Court 12, sua sponte, reset that case to a different date, probably because your case was pending. They reset it to November the 9th. I didn't ask for it. I've communicated with the court to try to get him in to resolve it because your case will be dismissed. So that's, I mean, to no fault of anybody really. He apparently was unclear on today's court setting, although we didn't notify him to be here. I can run him down here, Judge. I have contacted him right now.
You need to run him down here, and I'm calling County Court 12. So run him down to County Court 12.
Okay. I do have other settings this morning, so I will try to. We have a setting on the 9th, and I've made them clear of what's going on.
My thing is, why put off for tomorrow what you can do today?
Okay.
And Lupe, if you can call the court coordinator in 12 and tell them this person is coming over to plea. Who's here on Cruz? Rivas? And where is Rivas?
I've got motion for psych evaluation filed on that case. He's already been found incompetent last year, so I filed a motion for competency insanity on him.
All right, so the competency evaluation has already been filed?
Yes, they've been filed.
All right, Ms. Ferguson? What date are we bringing Mr. Cruz Rivas back?
I can do, December 5th.
All right, can you, Deputy Laura, if you can let Mr. Rivas know that we're gonna bring him back on December 5th?
All right, Judge, excuse.
Yes.
That's just a vote speaker.
No. All right, thank you.
Arturo Vargas. Hold on. I have it. I have it ready.
Who's here on Ryan Halton? Okay.
Your Honor, I talked to Brittany and my client, they're being often won't accept that he's from Jamaica.
No, I mean, he's already got an immigration attorney, so what's up with the compromise?
That attorney again.
Yes.
Excuse me, ma'am. They gave me an offer and stuff today because they dropped it from a felony amount. And stuff, so it's not misdemeanors and but they're also saying my probation might not be used for current probation anymore. So I would like different, I would instead.
All right. Do you have your immigration attorney's phone number?
Yes, ma'am, I've been in contact with her and I've been.
All right. Can you call her and let her know what this offer is? All right. So just step back and he's going to call the immigration attorney.
Okay, yeah.
All right. Thank you. Brennan, Brenna, are you able to do something or you want to wait?
I can go.
You sure?
Yeah.
Surely.
All right. Who's here on Kevin Lawwill? Okay. See, everything works out for the best, right? Who's here on Sherry Cooper? Hello.
Your Honor, despite your rules, I have not talked to the prosecution, but I did talk to the probation officer. I figured she was the one that was going to be involved in this.
Okay, but no, probation would probably still be, somebody to confer with.
Well, the issue here is she's supposed to go to DDRF
Mhm.
as a condition of her staying on probation
And that hasn't happened because they're backlogged, right?
because she has a case pending in Bastrop, and so they won't even put her on the list.
All right, so what is her case pending in Bastrop?
Possession of a dangerous drug and failure to ID. The dangerous drug was antibiotics, infection.
Okay. All right, then let's do this with,
I have to put a couple more things in front of you, though.
yes,
She also has an ICE hold because she's a British citizen.
is this where everybody starts speaking with British accents?
I hope not.
Immigration plans to pick me up, and we made contact with Bastrop County.
Mhm.
And the DA said that there's no court date there for me. Yeah, it's a back. It's at least 46 months minimum before they have a court date for me.
And I do not represent her in Bastrop County.
All right,
What I'm asking is you consider going ahead and releasing her on outpatient treatment. She has I believe, a 3-month-old that she would sort of like to be taken care of.
Ms. Boydman, I want to tell you something. The difference between me standing here when I got sentenced to probation of 7 years deferred adjudication, and now is that immigration has given me a chance. They're giving me a social security number, and they're giving me the paperwork that I need to be able to go get an ID and a driver's license. I haven't even been able to drive legally in the United States in the last 15 years. I haven't been able to do anything legally, let alone work. And they're going to give me my work authorization card. It's me as a person and the tools that I'll have and the capabilities that I have now is so wildly different than it was just a few months ago when I got put on this probation. Like, this is a chance I've been waiting for 15 years. is to be able to have the tools to do what I need to do, stay sober, to be good, to be able to provide for my children. I have 6 kids in the United States of America. And immigration might let me go when they pick me up, but I can do this now. They're giving me the tools.
All right. And probation.
Instance of outpatient treatment.
Okay. All right, then what I'll do is, I'm gonna do intensive alternate mean conditions. Oh, I'm sorry, probate, state. This is Miss Cooper. This is the situation with her case. She can't go to DDRF because she has an ICE hold, because she's not a US citizen. And also she has pending cases in Bastrop. So she's sort of in limbo. So to help take her out of limbo, probation has suggested intensive outpatient treatment, which I'm in agreement with, and we can do weekly reporting. All right, so we're gonna do intensive outpatient treatment.
And if the top is needed with that judge, I'm not quite sure when it's going to complete. And I have that.
Yes, and we'll do TAP evaluation out of custody. Here's the thing, I'm gonna do TAP evaluation out of custody. But if you don't report for that TAP,
Yeah.
when you're released, you're gonna be back in custody, you understand?
Yes, fully.
So intensive outpatient treatment, TAP evaluation, and we're gonna do weekly reporting. By Zoom or in person until in custody. I'm sorry, until in treatment. There's going to be parenting classes and no unsupervised contact with minors. Now, that will change if you show the court that you're serious about being upstanding and being a good parent.
Yes, okay.
I don't know if Child Protective Services is involved. Are they involved? Is anyone else?
Case is closed.
All right.
They're not involved currently.
Well, I'm gonna put CPS compliance
Yes, ma'am.
if it's applicable. So if there is no CPS investigation, then of course there is no CPS compliance needed. And I'm gonna want field visits 2 times per month. And that'll be until further notice. Is there anything else you need from the court?
No, ma'am, thank you.
Anything else she needs? Mr.
Thank you,
Young?
Your Honor.
All right, good luck on the Magnolias.
I'm hoping tree looks healthy, but the seed pods are
Tiny.
are just like little tiny peanuts.
Okay. All right. Thank you so much.
Thank
Have a
you.
good one. You're welcome.
You're on, I'm ready. I'm Ryan Hampton when you're ready.
Ryan Halton. Hi. Did you get a chance to speak with your immigration attorney?
No, no, I thought I had a number locked on my phone, but I did not. She recently just been calling me, but I do have emails.
All right, Ms. Ferguson, did you give him Ms. Davala's phone number so you can call her?
Oh, excuse me, ma'am, what I really wanted to say also, because
Why are you whispering?
I don't know, I didn't know if you want to get a speaker.
Yeah, because I can't hear.
Yes, ma'am, but now I was just saying, ma'am, because I haven't had any sleep in 3 days, and I just got out of.
Why not?
I just got out of magistrate at 4 a.m. this morning.
Why were you at the magistrate?
Because they arrested me for an unlawful carrying that was my girlfriend's firearm, and she was in the car with me and it was unloaded and was in the glove compartment and everything. So they had
I do have some concern about his mental ability at this moment.
All right, y'all coming back on the 31st.
Thank you, ma'am.
Thank you, Your Honor.
Thank you.
No, you need a reset form.
Just hang on a sec. Norma, do you want to have a reset?
Yes, I need to be honest.
Thank you, Your
Just
Honor.
go to
You're
the,
welcome.
go to the other side of the bar.
And who's this?
This is Halton.
Oh, yeah.
Who's here on Armando Jimenez? Armando Jimenez. And where is Armando Jimenez?
I have the sticky for both of them. I have tickets in a little white piece of paper. I think that'd be-
All right, what day do you want to call it back?
November 7th.
No, this was set for a plea deadline today. Well, actually, it was set for a plea deadline date on October 14th, and the attorney wasn't here. Do you know when he'll be available?
I don't know, he's. I have no idea. What, when do you want to?
31st. Deputy Laura, can you let Mr. Jimenez know his attorney is ill, so we're going to bring him back on the 31st?
Yes, yes, Your Honor. Mr. Hickman is also in custody. And he does have
31st.
Thank you.
Just a moment. Deputy Laura, we'll still put Hickman on the 31st, but somebody has written inside the file that it's November 7th, but just put it on the 31st.
If he was here for a month. Keep the bond on the first.
Yes.
Okay.
Put the whole case on the 31st.
You know what?
Yeah.
Kevin Lawhill. Lawwill. Kevin, oh, we're still waiting for your attorney? All right, they're not ready. Andy Maldonado Rivera.
Morning, Judge. My client's in custody. Would you like him with here too?
Yes.
Okay.
All right, where are we on this case?
Judge, I reviewed the case file. There was the defendant considered to a search of his phone, which based on the victim's statement, there would be evidence of this potential crime on the phone. I don't have a copy of that. Without reaching out to Kirby PD to get a copy of it. Otherwise, it appears that all the discovery is placed. Once I review the phone, just to make sure that there's no inculpatory or additional inculpatory or exculpatory evidence on the phone, then I'll be able to tender an offer. So since it's a consent to search case, it should not be an issue of getting the extraction done. It should have been done. I'm imagining that it is done, but I don't have that information right now.
Okay, is 30 days enough time?
It would be sufficient for us.
All right, Ms. Ferguson, I need a 30-day reset on Maldonado.
November 17th.
All right, we'll be back on November 17th.
Thank you. Do we need to sign or?
No.
Okay, thank you.
Yeah. Now,
Who's here on Marquise Garcia? Who's the attorney for this person?
there's our bank pass.
Why were you late?
I have to drop my son off.
All right, so here's the thing. I understand that people have things they need to do, but court starts at 9. So if you were in jury trial, we will be waiting for you. So you're gonna have to make arrangements. You understand? What's happening with this case?
It's a trial case.
All right, so today was his plea deadline date. Is he rejecting the offer?
Yes, sir.
State, how many days will this trial take? Oh, it's family violence. Michael Villarreal.
I thought he was reading and gonna.
What case is this?
It's Marquise Bossier.
I'm sorry, I can confer with the court, chief. I don't know. anything about it.
Page 6.
All right. Have you conferred with the state recently?
Yes, last setting. Confirmed.
All right, you want to talk to the
I
state?
don't know how long it'll take, Judge. I'd have to.
All right, so confer with the state. Nobody approaches before you speak with the state. Just have a seat. They're not ready.
It's what you're filing. Thank you.
Can I see someone from Criminal Trial Division? Thank you. Who's here on Sergio Garcia?
Your Honor, good morning. Frankie Sandoval on behalf of Mr. Garcia.
And where's Mr. Garcia?
Mr. Garcia is in custody. He's going to be brought up so I can speak with him, Your Honor. But I have conferred with the state, approached the state. Marcus will be the lead assistant district attorney on this matter, and he's out this week. Because the complaining witnesses need to be contacted, an offer is not available at this time. I was just approaching the court to inform the court of that.
All right, thank you so much. We'll wait till your client comes out.
Okay. To approach on the reset judge or?
Yes.
Okay, I apologize. I know you need to have him here for that. as
No, I
well.
mean, you're calling him up, correct, to speak with him?
Well, I want to speak to him about the setting, but not knowing the court's said trial was in session. I wanted to,
Oh,
yeah,
yeah, move it quickly. I appreciate that. We're not starting up with, back up with trial till after lunch break.
Okay, so I'll let the staff know when he's here. Thank you, Judge.
Okay, you're welcome. Always good seeing you. I'm used to seeing you in a box with the Academy, with the Emmy behind you.
Well, no, I was gonna say, hopefully not the jury
Jury
box in
box, yeah.
custody. Just want to clarify.
Yes.
That was only once, and it really wasn't all my fault.
Okay. All right, where's Yvette Hernandez? Hello.
Good morning.
Good morning. Why were you late today?
I went to the wrong building. And traffic.
All right, you actually got probation out of this court, so you know where the courtroom is.
No, I never actually came to the court. I think I've had through Zoom.
Oh, okay.
Yeah.
All right, so we have an issue. You've already been extended.
Mhm.
And because you're not doing what you're supposed to do, and I understand everyone has issues in their life,
Mhm.
but I can't have somebody on probation
Mhm.
who gets terminated just because life has, been a speed bump in their
Mhm.
life. You have to do what's required of you on probation.
Mhm.
So let me ask you this, if you're drug tested today, what are the results going to be?
Oh, I'm clean.
Okay, all right, so we're gonna do a drug test today.
Okay.
And I see that you're only working part-time. Have you looked into getting a second job?
Yes, ma'am. I just started a new job on the 6th. I work for a hotel. My room attendant. I'm full-time.
Okay,
So I'm just waiting on, I guess, pay.
all right,
Yeah, yes, ma'am.
all right. So what we're gonna do is do a drug test today.
Okay.
And once I get those results, I'll make a decision on whether or not to terminate her. All right, thank you.
Okay.
All right, who is the prosecutor on Yvette Hernandez? It's an aggravated assault with a deadly weapon. All right. All right, on this case, probation is asking that she be terminated unsatisfactorily. She's done everything except for paid monies. So right now she's going to do a UA for me. We're going to see what the results are. So I don't know if the state would have any objection to that.
Okay, I'll look at it.
Okay,
We don't have.
all right, thank you.
And Judge, I'm always there. The state's ready.
Okay. All right, Marquise Bozier. All right, where are we on this case, State?
We're discovery is
thank
complete,
you.
judge. We've extended an offer. If I understand, if they don't want to take the offer, as far as a time announcement for trial, I anticipate that no more than 2 days.
All right, Ms. Ferguson, can I have a jury trial date for Marquise Bossier? State is telling me it's 2 days.
And 5 days, judge, so I clear two full days. Not 2 half days or 2 3/4 days.
But if, you know, if things go by quickly, then sometimes 2 days is
Two
a half
days.
day.
I would err on the side of caution.
Okay,
So 3 weeks.
but how do we calculate that? Do we
There's no
consider
way.
8 hours a day as a full day? I don't know.
I think it's, an hour for one. Six.
You know, there's a song, what a difference a day makes, 24 hours. But you know, when you get through the end of that song, it says, the difference is you. All right, Ms. Ferguson, do you have a jury trial date? All right, December 5th. December 5th is your jury trial date. You'll be sent to impact court. You need to be on time, otherwise a warrant may be issued for your arrest. The court will not consider any plea bargains in this case without good cause. Do you understand? All right, and State, can you provide the court with an acknowledgement discovery?
Yes, sir.
All right, thank you. Ms. Ferguson will give you a reset form.
Judge on event.
Yes.
Right.
Okay, all right, we'll see what the results are going to be. I believe the results will be negative. I'm putting that out in the universe. All right, who's here on Arturo Vara? All right, Brenda, are you ready?
Yes.
Court is calling 2019 CR 12034, State of Texas versus Arturo Vara. Can I have parties announced for the record for the state,
Ryan Brewer for the state of Texas.
for the defense?
Alfonso Cabañas for the defendant.
And are you Mr. Vara?
Yes, ma'am.
All right, defense has filed a motion to modify pretrial release conditions. The defendant is currently on GPS. The defense is asking that the defendant be allowed to work from Thursday through Sunday from 10 a.m. to 7 p.m. Is that correct, defense?
That is correct, Your Honor.
All right, State, have you had a chance to review the defense's motion?
I have, Judge.
And are you in objection?
Judge, we're not necessarily objecting just because it's a modification of the GPS, but we are going to defer to the court on it. I believe probably our concerns are the same that the court has, is that he has some pretty serious criminal.
All right, so State, is there any concern that I guess witnesses or someone would not be protected if he's allowed to work Thursday through Sunday at a specific location?
Correct. I mean, Judge, what I can tell you is obviously there's always a concern of that. We don't have any absolute reason to think that. But what we can do is let a couple of the witnesses know the situation, so at least they're aware of that. But I don't believe we have any knowledge that that location is somewhere where our witnesses are.
All right, well, this is what I want to do because the state has brought up a matter to the court. State, if you could speak to your witnesses and see if there's an issue and let them know where Mr. Vara will be working. Do you have an address that you can give to the state?
I do, Your Honor.
All right, if you can give that to the state, and State, will you be able to let your witnesses know no later than next week?
Yeah, I can do that. Judge.
All right, so what we'll do, Mr. Vara, I just want to be sure that any witnesses involved in this case are aware that the court is considering allowing you to work at this specific location. And if there are no issues, and when I say issues, that this location is not near them, we can have a brief hearing and the court will take care of it next week.
Regarding this matter, Judge, again?
Yes.
Okay.
Yes, and, but I just want to make sure that parties involved know that he will no longer potentially be on full house arrest, that he'll be working at a specific location. And, Ms. Navarre, I'm not saying that you would do anything. I don't know any facts about this case because nothing has been presented to me. I just want to make sure that all parties involved know specific locations of person. And that's as much to protect you as anyone else. Okay?
Judge, may I address some of the court's concerns regarding the witnesses? Maybe hopefully it'll sway the court's mind to rule on this today. So it's a recently indicted murder case based on an allegation that happened many, many years ago. Regarding the court's petition to notify the witnesses, what I can tell the court without going too much into detail is that the only alleged eyewitness in this case is somebody who, I guess, at the time of the statement regarding this matter was in custody, but it's not an eyewitness, Judge, that has anything to do with the victim or anything to do with Mr. Vada personally. It's just someone who, while in custody, gave a statement regarding Mr. Vada's offense, but it's not someone, in my opinion, that's in any danger whatsoever or should be the least concerned regarding Mr. Vada being released, or at least monitored while he's going to work and back.
All right, and I understand, and Mr. Barr, I do, both defense and state are officers of the court, and I take what they tell me as true because they are officers of the court, but there are other people involved other than yourself. State, if you're able to do it sooner than next week, and when I say next week, I'm thinking Monday. So it won't be this big gap that will be coming back on Thursday. I just want to make sure that all parties involved in this case are aware. And it's as much to protect potentially anyone who's involved in the case as well as Mr. Vara. Because the last thing I would want to happen is he's driving on a street or going somewhere and somebody sees him and says, hey, you know, this is where I stay. I don't even know where this complainant stays. I don't know if he stays near this location. That's just something that I need to know.
Yes.
All right. So, Mr. Groomer, are you able to do this by Monday, you think?
I think so. I think I can do it by Monday. We've had good contact with the individuals that we're talking about, and I think I can do that by Monday.
Okay, and Mr. Cabana, so you're able to come back on Monday?
Yes, Your Honor, I am.
All right, and Mr. Vara, are you able to come back on Monday? All right, and I tell you what, before I even call docket, if all parties are here and have the information for me, we will take it up exactly at 9 a.m.
Perfect, Judge. In a related matter, let's see, we were here September the 12th, Your Honor. I think it was a discovery acknowledgement or discovery compliance matter. I think the court put on the record that the state provided defense counsel with an additional statement given by this witness after he was released from custody. I think the state's looking for it, but if the state's going to talk to this witness before Monday, I want to put on the record that that second statement that the state is going to provide to the defense counsel will be provided on Monday as well.
All right, is there a second statement?
I believe there is, Judge. I don't know what format it is, but I will double check and see if I can get it back to Mr. Cabanas on Monday.
All right, and I will tell you both, I don't have an acknowledgement of discovery yet, so once that statement is provided, then you all can look over everything and see
Yes,
if
Your Honor.
there's an acknowledgement of discovery. Ms. Ferguson, on Vera, can we recall this for Monday? All right, so we'll come back on Monday at 9 a.m. and hear this matter.
Yes, Your Honor.
All right, thank you.
Thank you, Judge.
You're welcome.
Thank you, Judge.
You're welcome. Here. Pierce Jones.
Um, 120 day, psychiatric treatment. He is not competent.
Okay. Ms. Ferguson, on Mr. Jones. We're gonna have to do a reset date on him. And you're saying that he's already been determined to be incompetent?
He is determined to be incompetent. He's had that status now for about a month. But the way that they're taking, I expect quite a few more months.
All right, Ms. Ferguson, on this one, we'll need a phantom date, so if he needs to be transferred, is he still at the Bear County Jail?
Yes.
So on this one, do a phantom date?
Pierce Jones.
Yes.
Page 8. I want to say September 20th.
You said what, George? I'm sorry.
Oh, we need a phantom date. And he hasn't been transferred yet to the state hospital. Yes, just to see where we are. Do it like January.
I can do January 31st.
January 31st, yeah, that's good.
All right, we'll see you 31st.
Thank you, Judge. May I be excused?
Yes. Who's here on Richard Gonzalez?
Yes.
Where's Mr. Gonzalez?
No idea.
All right, could I have a prosecutor, please? Court is calling 2022 CR 9439, State of Texas versus Richard Gonzalez. Can I have parties announced for the record for the state,
Daniel Escobar for the state of Texas.
for the defense?
Glenn Pam for defense.
All right, this was scheduled at 9 a.m. It is now 10:02 a.m. The defendant is not present. The court received a violation report. And the violation report is that the defendant has not contacted pretrial services. Defense, have you had any contact with your client?
I have not had any response from my client.
All right, and Deputy Laura, is there a Richard Gonzalez outside the courtroom?
No, Your Honor, there was a.
All right, state.
Your Honor, the statements for a bond forfeiture at this time.
All right, and the court will note for the record that this case was previously set on October 18th, and the defendant was a no-show at that time as well. The court, because this is a PR bond, the court will issue a judge's warrant and remain your client without bond. If you get in touch with your client, he makes an appearance, the court will reconsider.
Thank you, Judge.
All right, yes, thank you.
I've seen Wilson. Yeah.
That warrant on Dimitri, what is it? Dimitri Gomez.
Yeah, that's a judge's warrant. Oh, wait 1 second. Could you call him back? Deputy Laura, you said Richard Gonzalez was in jail? All right, let me see that file back on Richard Gonzalez. And Norman, can you get Mr. Payne back here, please? Okay, all right. Thank you. Can I see the file on William Webster? Webster. Webster? Yes. All right, Ms. Ferguson, I need a reset date on Webster. Yes, he's ill. William Webster. He's ill. He's ill. Yes. Yes. Megan McCloskey.
Here you are.
Thank you. And Brenda, do you see what page she's on?
Yeah, she's on 7.
All right, Mr. Porter, what is happening with this case?
Respectfully, Your Honor, the court appointed me a few weeks ago.
Yes.
I read the file. There was a couple of search warrants that I could not find. The state just pulled them up and found them to me. Reading these, Judge, if I could get a little bit more time, because there's some legal issues I need to research.
Are you chewing gum?
I'm so sorry, am I not supposed to?
Yeah.
I apologize.
That's okay. You know what? I say that every,
Put it on the bottom of your sheet.
I apologize. I spit it
that's
out
okay.
in my pocket.
Oh, I mean, you can put that in your pocket.
Forget to launch it.
Yeah.
It's with their patients.
No, you know, my motto is that as we move about the planet, we're supposed to be learning things every day. So now you know, so it won't happen again.
Yes, ma'am.
So that's a good thing. All right, is 30 days enough time?
It should be, Judge.
All right, Ms. Fergus, can I have a 30-day reset on McCloskey, please? And it's a regular reset for discovery.
November.
Yes, all right, so we'll be back on November 17th. Is there any other outstanding discovery?
No, Your Honor. Not that I'm aware of.
Not that I'm aware of, there's almost 300.
Okay, we'll see where we are on that date. Ms. Ferguson will give you a reset form.
But she's gonna tag me out.
All righty. And Norma, did you get a chance to call Mr. Payne back? Okay, if you'll call him back, please. Okay, this is done. All right. Okay. Oh, no, go ahead. I mean, the next is I think it's sentencing, but go ahead. I'll move around.
Okay, I'll be right back.
Okay. Who's here on Sergio Garcia?
Good morning. Let's be fair on behalf of Mr. Garcia.
All right, Mr. Garcia, come up. And you are requesting a reset on Mr. Garcia?
Yes, Your Honor.
All right, and where are we on discovery?
I believe everything, well, I have no reason to believe that there's anything that has not been uploaded.
All right, and state, are you prepared to make an offer today or no?
No, Judge, we need to contact the complaining witness.
All right, Ms. Ferguson, can I have a 30-day reset on Sergio Garcia, please?
November 17th.
All right, we'll be back on November 17th, Mr. Garcia. At that time, the state will make an offer to your attorney, who will make the offer to you. Then what will end up happening is I'll give you a plea deadline date, okay? All right, thank you.
Hello,
Hi, how you doing?
I'm good. I'm from next door and I'll be with you this morning.
Okay, awesome, thank you.
Sorry. No worries. We got it. Okay. I've got another one to do.
You ready on that?
Just whenever she's ready. Just in here.
What's your name?
You know.
Let me know when you're ready to go.
I'm ready, Judge.
Okay, and we're just waiting quickly on probation,
Okay,
and then we'll start.
okay, but you'll tell me we're on the record.
Yes, I will.
Okay, perfect. Thank you.
Who's here on Ascend Wilson? Why were you late for court?
My overdrive was end up having some car difficulties way over there.
All right, so here's the thing, and I'm going to tell you what I tell everyone. You need to make arrangements in your schedule for unforeseen consequences. You understand? That is why I always set everything in my schedule 30 minutes early, because you never know what's going to happen, but you'll still be on time. What is happening with this case?
Judge, I believe the state just needs about a week to get a resolution to this. We're very close to getting this done, but they haven't had a chance to, as far as I can tell, do a deep dive and discover it as far as this. I know Ms. Spark was out for a little bit, Judge. I knew she's gonna be handling this case going forward.
All right, because what I have in my notes is on September 22nd, an offer was tendered and all discovery had been received.
We have everything, Judge. But there's an issue with this question that we definitely need to file if we can't reach this resolution in the bounds outside the court.
When is that going to be filed? Some
I can get
suppression.
it filed immediately, but I was hoping we can avoid all that once everybody gets a chance to look at the actual discovery. I know when this Sparks was out, they hadn't had a chance to actually look at the discovery yet.
All right, so if a motion to suppress is had, is this going to be dispositive?
Yes,
All right, and how many witnesses would we expect on a motion to suppress?
we would probably two.
Two, okay. All right, Ms. Ferguson. Can you recall this? State how much time do you need?
Give me a week for the issue that the defense counsel brought up. I can have an answer. As far as this, if it's a motion to suppress, I'll have to bring an option for that. So I would request 30 days for that.
Okay. All right, Ms. Ferguson. On this, recall this in 30 days for a motion to suppress hearing. If things work out and the hearing doesn't need to take place, then it won't take place. But if we need a hearing, it will already be set and you'll need to file that motion.
I will do that, Judge. Thank you.
And they're saying it'll be about 2 witnesses.
Let's see. Yeah.
All right, November 14th, 11 a.m. is your motion to suppress. And you need to make sure you're on time.
Thank you, Judge.
Yes,
Maybe
ma'am.
excuse.
After you get your reset form.
Need to refer to Joshua Gonzalez, please.
Here you are.
He's coming out. Not fine. Yeah. He's coming out. Yes.
Who's here on one? Let me know when you're ready. Juan Carranza. Juan Carranza. All right, come forward. All right, what is happening with Carranza?
Yes, Judge, I believe it's our first, at least it's my first appearance on this case. I spoke with the state. They had some results that they just received yesterday and want to review some of the results and some pictures.
I should say, Judge, this is the case where he was at large, and so we got a buckle for him yesterday.
Okay,
So we already have the DNA result as it relates to the evidence collected as the same, but we don't have the comparison.
all right. And how long does the comparison will usually take? Because I know there's a backlog.
Last time I was talking to them, they were talking about 2 or 3 months.
All right. Ms. Ferguson on Carranza, can I have a 45-day reset? We'll see where we are at that time. And that'll be for the DNA comparison update.
We can come back on December 8th.
All right, we'll be back on December 8th to see where we are.
Thank you, Judge.
All right, thank you. Who's here on Julianne Hughes? Oh, Julianne Hughes. Or is it Julianne?
It's Julian Kane.
Oh, Julianne Kane. Okay. All right, so what's happening down below?
Well, so I spoke to Judge Huff directly. I don't know if you actually tried to make contact with her. She has today is her busiest day. She has her DDF, RF, her PTD, and then a regular docket. She is on the bench. She did inform me there's no way, because it's not set, that she could run something in and handle. She appears to be on Zoom as well.
Mhm.
So it's set on the 9th. She said, bring him in on the 9th and we'll handle it. So I would ask if you could move this to the 9th, and my expectation is it will be done. Again, they reset it on their own. I didn't ask for it. So it was a mistake or an oversight. I don't know.
And when are you saying this will be done?
November the 9th is when we're set. I have no reason to believe it won't be resolved on that day.
All right, so Mr. Hughes, the court is not giving a further reset. So November 9th is it. Can you give them a reset form, please?
Thank you, Judge.
You're welcome.
You tested positive. for
Alex
COVID.
Arizola,
Thank you for
come forward with your client.
Talking to one of his clients.
Oh, well, you're not ready then. All right. Let's have a seat. Stevie Stokes. Stevie Stokes. Your attorney's not here. All right, who's here on Jonathan Aguilar? Court, we're going to go on the record. Court is calling 2022 CR 6540, State of Texas versus Jonathan Aguilar. Can I have parties announced for the record for the state, for the defense?
Nathaniel Navy, Your Honor.
And are you Mr. Aguilar?
Yes, ma'am.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Aguilar, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge, I do.
State, are you proceeding on the indictment as presented?
No, Judge, we're proceeding on the lesser included assault bodily injury. Mary.
Any objection?
No, Your Honor, no objection.
Mr. Aguilar, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of assault bodily injury married as a Class A misdemeanor? The range of punishment for that offense is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case? Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Aguilar, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
No, ma'am.
He's not a citizen?
He's not a citizen.
All right. Counsel, did you have a chance to review with your clients the consequences of entering a plea in this cause?
Yes, Judge, I told him that he would likely be deported. He understands that.
All right. And did your advice include consequences such as deportation, the denial of naturalization and re-entry into the United States?
Yes, Judge.
And do you believe he understands the consequences of entering a plea to this lesser included offense?
I do believe he understands that, Judge.
Mr. Aguilar, have you been advised of the consequences of entering a plea of no contest or guilty in the application of federal immigration law as it relates to this lesser included offense? All right, did the advice you receive include possible consequences such as deportation, exclusion from admission to the United States, and the denial of naturalization? And did you understand the consequences of entering a plea? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Everybody in the box, I'm going to ask you to please whisper. You're talking behind the court reporter. I'm going to show you what's entitled plea bargain agreement. Did you review that with your attorney? Did you understand it? According to the plea bargain agreement, there's to be 1 year in the Bexar County Jail, a $750 fine. State will take in consideration 2022 CR 6541. There's to be no contact with Sophia Loren Tovar. And it is not listed on here, but do you understand that if the court find that this is family violence, there will be an affirmative finding of family violence? And did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? And did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that to be the entirety of the plea bargain agreement? Defense?
Yes, Your Honor.
State?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor. they have
Then
not.
to the offense of assault bodily injury married as a class A misdemeanor, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Judge, we offer what's in Martha's state's.
No objection.
Mr. Aguilar, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just ask that you follow the plea bargain agreement, Judge.
All right, the court will sentence you to 1 year in the Bexar County Jail. There's a $750 fine, time and money to run concurrent. There's to be no contact with Sophia Loren Tovar. There's an affirmative finding of family violence. And taking consideration 2022 CR 6541. Is there anything else from either side with regards to sentencing?
No, Your Honor. For just that the other case was being taken into consideration.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Excuse me. And because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Mr. Aguilar, you need to change your ways. Otherwise, you're going to be in and out of jails, in and out of prisons. Do you understand? Do better. Good luck.
Thank you, Judge.
You're welcome.
Judge, did you ask me to come back on Mr.?
Yes, he's in custody.
Yeah.
So he's here.
I looked at, guess he went 10-10 or something like that.
Yes. So they'll bring him out. Court is calling 2022 CR 8213 State of Texas versus Dimitri Gomez. Now parties approach and announce for the record for the state,
Michael Hillary out the state.
for the defense.
Scott McCoy for Mr. Gomez.
All right, we are here for sentencing. Are you Mr. Gomez? All right, you're gonna need to speak up, okay?
Yes, ma'am.
We have, I don't mean to interrupt you, Judge. We have a request. I don't know if you were about to sentence him, which I'm sure you were.
Mhm.
Mr. Gomez is asking if you would consider his significant other has a due date for their child of November 22nd. He wanted to see if you would consider allowing him, resetting the sentencing again, to allow him time to be present at his child's birth on November 22nd. What we didn't expect this morning is that the bondsman went off his bond for a payment dispute.
Mhm.
And so technically, if you were to consider allowing that, then he would need to go into custody, and then his mom would go and try to settle with the bondsman so that he could get out. But that's our request, if you would. consider
And who's the mother of your child?
that. Who's the mother of your child?
Chelsea Lopez.
All right, so Mr. Gomez, I reset this for you to have time to get affairs in order. And so this has been set since, well, you enter your plea on September 22nd. So I'm going to go forward with the sentencing. So as previously stated, the court had found you guilty, found the enhancement true. And at that time, there was a warrant, and the court recalled the warrant so that you could be out to get your affairs in order. Court will sentence you to 4 years in the prison, give you credit for any time served, taking consideration 2022 CR 5520. There's an affirmative finding of family violence, and there's to be no contact with April Guerrero.
And just, you know, that reason I'm not giving you dismissal, that case has already been closed.
Okay.
To take into consideration.
All right, thank you. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? And also, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand? All right, good luck to you. Who's here on Antonio Davila? Hello. All right, the court is calling 2019 CR 11422W, State of Texas versus Antonio Davila. Can I have parties announced for the record for the state,
Brian Grimmer for the state of Texas.
for the defense?
Jason, it's.
Are you Mr. Davila?
Yes, ma'am.
Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Are you the same Antonio Davila who was placed on deferred adjudication in 2019 CR 11422W for the offense of possession of a controlled substance, penalty group 2, 4 to 400 grams on October 16, 2019 for a term of 4 years? Is that you?
Yes, ma'am.
State?
Yes, Judge. Violated condition number 1, on or about the 24th day of February 2022 in Uvalde County, Texas. The defendant, Antonio P. Davila, committed the offense of burglary of vehicles in violation of condition number 1.
How do you plead to that? True or not true?
True.
Violated condition number 1, on or about the 24th day of February 2022 in Uvalde County, Texas. The defendant, Antonio P. Davila, committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true?
True.
We waive the remaining conditions.
Any objections to the state's waivers?
Yeah.
All right, Mr. Davila, did you understand by pleading true to violations 1 and 1, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 1 and 1?
Yes, ma'am.
Court will find 1 and 1 true. Is there an agreement?
There is an agreement, Judge. we have an agreed recommendation from the court that you deny the motion to enter an adjudication of guilt, but alter and amend Mr. Davila's conditions to include state ISF, the cognitive and substantive track or substance track.
Is that the agreement?
That's your.
All right, Mr. Davila, do you want me to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
What's going to be different? Because you're on probation out of this court and you have 2 new cases out of Uvalde. So what's the difference? Why should I follow this agreement? Why shouldn't I send you to prison?
Judge, may I
Yes.
interject? The state offered 2 years, and in which case you would probably do less time and
All right, so I
you-
don't tell me what the plea bargain agreement is, because that's,
He's opting for this option so he can get treatment. And he wants to go forward. He wants to do better. And he specifically asked for treatment, and we've been here several times so that we can arrange things with Uvalde so that he would be able to go to get treatment.
all right, is ISF going to accept him? Is there gang affiliation or something in his background that I don't know about that would preclude him from being accepted in ISF?
The probation has reviewed it and he hasn't been interviewed yet, but we believe he's eligible for ISF.
If he's being affiliated, they will not take him.
You're not gang affiliated? Well, here's the thing. A lot of people have a different definition of gang affiliation. So have you ever belonged to a gang?
No.
Have you ever been to prison and signed up?
No. They put me on gang unit, but for, I don't know, for what.
He was on gang unit, but, I mean, I can have an investigator run through the text gang thing and see if he's got been documented.
All right, so what I'm gonna do, I'll follow your agreement. I'm gonna deny the motion, alternate amend conditions, state ISF, cognitive and substantive track. Here's the thing, you're either gonna make a decision to do better with your life or you're not. If you don't want treatment, if this is just, oh, I don't want to go to prison, so let me get treatment, I'm not really ready to change my life, you need to let me know now, because guess what? There are other people who really want the treatment and they're going to take advantage of it, and they're trying to work through whatever trauma they have to come out on the other side. So who are you?
That would want treatment, want help.
Okay, all right. That's the court's order. Probation will go over conditions with you. Who's here for Yvette Hernandez? Yvette Hernandez, can you come forward? Yes. What were the results? Thank you so much. I'm glad you are getting your life in order. All right, so I don't want to see you come back here again before me unless you're coming to visit. You understand? The court is always open. I'm glad that you've gotten on track with getting employment and taking care of your life. Okay. All right, so it's an agreed to terminate her probation. We will terminate her probation satisfactorily. You are done.
Thank you.
Don't, if you're going out to celebrate, celebrate with a lunch. Don't celebrate doing anything else, okay?
Thank you.
All right, you're welcome. Who's here on Sharona Williams? Good morning. Good morning. So what is happening with this case?
Your Honor, we tried to negotiate this.
Everyone needs to whisper.
We're unable to reach a disposition. I think we need a trial.
All right, Ms. Ferguson, I need a trial setting for Ms. Williams. And state when you get a chance, if I can get an acknowledgement of discovery.
Yes.
All right, so your plea deadline date has expired. What that means is that the court will not accept any offers in this case without good cause. Otherwise, you have to plead open to the court. Do you understand? All right. All right, we'll see you on December 5th for your jury trial. Ms. Ferguson will give you the reset form and make sure that you sign the discovery acknowledgement and then you are excused.
Thank you, Your Honor. I'll do that.
You're welcome. Who's here on Stevie Stokes? All right, we were here, and the last time we were here, there are some autopsy results that are not done, or,
They're still not done, Judge.
all right,
And I haven't been able to follow out this judge, but really last night, they were so unavailable. I reached out yesterday about a different matter. They're indicating to me that because of the backlog, they haven't been able to expedite a lot of it.
all right, Ms. Ferguson on Stokes, could I have a 45-day reset?
Your Honor, on the Stokes matter, since it is now a first degree as an injury, I have filed my motion withdraw. I'm only on the second and below.
Okay,
for the court.
I only have one filing, and it's just the endangering a child. I don't have a new, so has he been indicted on a new case?
I have. I have it as an injury.
All right, I have it as endangering a child.
Yes, I don't have any new read.
Okay, so there's nothing
Okay,
new.
so there's nothing new then.
Okay.
We're good.
All right, Ms. Ferguson, can I have a 45-day reset for discovery on Stokes, please? All right, Mr. Stokes, we'll be back on December 8th. All right, if there's nothing else,
Thank you, Your Honor.
you're welcome. Alex Arzola. Alex Arzola.
I'm here for.
All right, where are we on this case?
Your Honor, I've been extended an offer. We leave that to my client.
Good morning.
He's still in bereavement. He just buried his brother this week. So it's like, he's really not thinking clear.
All right, Ms. Ferguson, can I have a 30-day reset on Arzola
Thank you, Judge.
as a plea deadline date?
That'll work.
All right, we'll be back on November 17th. Mr. Arzola, I'm sorry for your loss. Ms. Ferguson will give you a reset form. You're welcome.
Thank you, Your Honor.
All right, just before he leaves, he needs to sign that form. For the parties on Genesis, Valela, and probation, this is for deferred. Court is calling 2022 CR 8250, State of Texas versus Genesis Valela. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense,
John Reitmeyer for the defense.
and are you Ms. Valela? Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client? Defense.
Yes, Your Honor.
Court will find the state is in compliance with discovery. Ms. Viela, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do waive, Judge.
State, are you proceeding on the indictment as presented?
We are done.
Ms. Viela, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with burglary of a building with intent to commit theft? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights? And if you intend to give up those rights and enter into a plea bargain agreement in this case? All right, so you're going to need to speak up so everybody can
Yes.
hear. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility, and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Judge.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Vieira, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that the defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, there's a $1,000 fine. State recommends deferred adjudication. There's restitution, if any, to La Islas Marias, Manuel Estrada Rodarte, Rodarte, and Cats 1 and 2. Did you understand those are recommendations from, did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense,
Yes, Your Honor.
state?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it, and did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 2 years. There be a TAP evaluation, 120 hours of community service restitution, no contact with La Islas Marias and Manuel Estrada Rodarte, Nick Mouth evaluation, and to follow those recommendations. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No.
State any evidence.
Your Honor, state offers states exhibit 1 and all attachments.
No objections.
Ms. Vieira, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor, we are.
Anything you wish to say on behalf of your client?
Just that we ask that you follow the plea agreement, Judge.
All right, and there's no belief that she was insane at the time of the offense?
That's correct.
All right. Ms. Vielas, is there anything you wish to say to the court?
No, Your Honor.
All right, are you on your medications now?
Yes.
All right, and who are you staying with?
My mother.
Okay, so do you have a doctor that you're seeing regularly?
Not here, but in Mexico.
All right, do you have a case manager? All right, so how is that?
My medication comes in from Mexico.
Your medication comes from Mexico? All right, so how are we going to do this here? Her medication's from Mexico, her doctor's from Mexico. But obviously she needs a case manager and somebody to make sure that she's taking her medication. So how's that going to happen? Because otherwise we're going to be back here for a violation. Probation, is there any way to get her a case manager? I mean, I know we can put her on the MIC caseload, but her doctor is in Mexico. And I'm assuming that's Mexico to country.
Yes, ma'am.
So. And you're gonna have to provide a prescription of your medications to probation, you understand?
I have it, but it's from Mexico. Like I have it, not right now, but I do have it.
No, just make sure you give it to probation.
Oh, okay.
Okay,
We can request her be on the MIG caseload as well as a referral to Center for Healthcare Services.
okay. All right, are you employed?
Not right now. I gave birth a month ago, so I'm taking care of my baby.
Okay. And the child is at your mom's house with you? Okay. All right, this is what the court is going to do. 2 years deferred adjudication. There's $1,000 fine. That's to be probated. There's restitution, if any, and no contact with La Islas, and I know I'm mispronouncing it, Laislas, Marias, Marias, and Manuel, I think I pronounced that correctly, Estrada, Rodarte, Rodarte. There's going to be MIC evaluation, a referral to Center for Healthcare Services. And this is not me trying to interfere with your relationship with your doctor in Mexico. It's just that I need someone here to make sure that you're taking your medications. You understand?
Yes, ma'am.
We're going to do parenting classes. There's to be regular reporting by Zoom or in person. There's to be no unsupervised contact with minors. So what that means is with your baby, your mom has to be with you. You understand?
Yes.
Now, I will probably change that once I know that she's on her meds, she's 100% stabilized, she's taking them on a regular basis. But for now, there's to be no unsupervised contact with minors. I'm going to want field visits 2 times per month until further notice. And there's to be regular UAs. With regards to cats 1 and 2, I honestly don't think this is cats 1 and 2 problem, but if it is, here's my course to you. Don't take what doesn't belong to you. Don't break windows, not even of your own property, because guess what? Once you break glass, I don't care how many years have passed. There's always some glass that you missed and it's going to end up in somebody's foot. I know this from experience. And it's from dropping a glass, not breaking, not throwing through a window. When you're on somebody's property, if you've been invited and they ask you to leave, leave. But the main thing, don't take what doesn't belong to you. And if you think someone has taken something from you falsely and they shouldn't have, call the police. All right? That's your cats 1 and 2 course. Consider that your certificate. We can put it on the record. You just got your certificate. Probation, is there anything else she needs?
No, Your Honor.
All right, I know I'm not going to put employment down. But I will say if she does get employment, if you do get employment, it is not to be as a home health care provider. It's not to be in any type of employment that involves minors. You understand? All right, and the reason why I'm doing that, because I know you need to take care of your mental health. You just had a baby, and I'm trying to make sure that you're successful on this. Okay?
You didn't want community service.
No. All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck with you. Just remain in the courtroom and probation will go over conditions, okay?
Thank you.
You're welcome. These are done. Who's here on Jesse Inaho? All right, what is happening with this case?
Judge, we've conferred with the state. They've conveyed an offer. My client has rejected the offer. So we'd ask to be placed on a trial docket.
All right, let me just find him on our docket sheet, just a moment. Okay. All right, you have all the discovery?
To my knowledge, yes, Judge.
All right, state if you're able to get the court a discovery acknowledgement on Jesse Hinaho. And when was the offer tendered?
I believe it was the last setting about 30 days ago.
All right. Oh, no problem. All right, so Mr. Inaho, the court will not consider any plea bargain agreements after today. If you decide to enter a plea, the court will only accept it with good cause. Otherwise, you have to plead open to the court. Do you understand?
Yes.
All right, Ms. Ferguson, can I have a jury trial date for Jesse Hinaho, please? All right, you'll be back on December 5th. Ms. Ferguson will give you a reset form and then you are excused.
Thank you, Judge.
You're welcome. After he signs everything. Here you are. Who's here on Hannah Smith? All right. It will just go to the end of the panel. Who's here on Eric Orta? All right.
Condition number 41.
All right, the court is calling 2020 CR 10019, State of Texas versus Eric John Orta. Can I have parties announced for the record for the state?
Michael Villery, off the state.
Defense?
on behalf of Mr. Orta, Your Honor.
And are you Mr. Orta?
Yes, Your Honor.
Showing you what's entitled motion to revoke deferred adjudication. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Eric John Orta who was placed on deferred adjudication in 2020 CR 10019 for the offense of assault of a pregnant person on April 6, 2021 for a period of 2 years? Is that you?
Yes, Your Honor.
State?
Violated condition number 41 on or about the 6th day of June 2022 in Bear County, Texas, the defendant Eric John Orta. Then and there failed to comply with the rules and regulations of the felony drug court by failure to appear in court. Violation condition number 41.
How you plead to that, true or not true?
True, Your Honor. The state would waive an amendment remaining argument.
Any objections?
No, ma'am, Your Honor.
Did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, find you guilty, not grant you community supervision and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand? Knowing that, do you still wish to plead true to violation of condition 41? Court will find violation of condition number 41 true. Is there an agreement?
Your Honor, the United States motion and alternate and conditions to include lifetime inpatient with lifetime recovery, as well as extend his probation for 6 years.
All right, so here's the question. Why should I do this? Because Lifetime Recovery is an inpatient facility, felony drug court, great program. And according to this, he didn't show up.
Judge, he, and I'm not making excuses, but just by way of explanation to the court, part of his problems is his own problems. He has a drug problem. And he's asking and wants to get some treatment and was in drug court and for significant periods of time during drug court was doing well, although he had some problems, obviously. And part of his problems were that he was trying to strike a balance between other things that he felt like he needed to do, his young child and the mother of his child, and drug court, and it became too much for him. And he obviously made some poor choices and was rejected or kicked out of drug court, or quit going to drug court. He's been in jail for over a month now. He has had a lot of time to think about it. We worked somewhat diligently to try to get him back into drug court. This is his first MTR. And he has seen the error of his ways, wants to get treatment. My office is called Lifetime Recovery and been able to discover there's about a week to a week and a half wait once there's an order in place for him to go to drug court. And that's what he wants to do. He wants to get some
So why
inpatient.
should I send him back to felony drug court?
Why shouldn't you send him back to felony drug
Yes.
court? I don't know that they'll take him. I don't think they will.
Because see, here's the thing, Mr. Orta. When people are in the throes of their addiction, they can't write their own plan. Because if you could write your own plan, we wouldn't be here. If I could write my own plan with dieting, I wouldn't be here eating chocolate. Although I do blame others for that, for giving me chocolate. But
Your Honor, if I may,
yes,
I did contact felony drug court and Judge Glenn said that he will not accept.
there's a reason for that. So my question is, why shouldn't he stay at the Bexar County Jail and go to safety?
I'll say that initially we were trying to get him back into drug court and this is the agreement that we both reached, just to have it clear that he needs inpatient treatment. So that's the agreement that we reached based on that common understanding.
So why shouldn't I send you to safety? They'll give you treatment. You'll be at the Bexar County Jail. They will have your full attention. You won't have to worry about other things in your life. Well, you'll be worried about them, but they will take care of themselves, but you will be going to safety. Because I don't even understand how things are going to be different. I mean, you still have a child, right? You still have other obligations. So I don't see how lifetime recovery is any different than felony drug court. It's all about balancing time and what's most important.
Well, and I'm not quarreling with the court, but
I know you're not, Mr. Kalfas.
the benefits, I guess his mother and father are present in the courtroom, and they've been very, very supportive of him throughout this process. He hasn't always listened to them, but they've always been steadfast behind him and supportive of him. And I think he's in a position now, obviously with a clear mind, a drug-free mind, to listen to them. And I think that if we put him in, say, in lifetime recovery, it would allow him at least, hopefully he doesn't come back to this court. I'm not standing before this court later on with Mr. Orta, but it would just seem like the next logical progression as opposed to Safe P. And I know the court has clearly the power to place him in Safe P, but Safe P is a long time program. It's away from San Antonio, so it would make things more difficult, not just on him, but his family to be there to support him. And it's just a more drastic program with regard. He hasn't picked up any new cases. He is near the end of his probation, or we wouldn't be asking for him to be extended. And it will allow him an environment where he can get treatment, and he can also have the backing and support from his family by way of visits and things that I think will help him be successful after he completes his treatment of lifetime recovery.
And
So that's,
And Mr. Orta, just so you know, I don't think Mr. Villarreal or your attorney have picked up any cases. So for me, do you get a cookie for that, for not picking up cases? Nobody should be picking up cases. You understand? And felony drug court, did they have you in inpatient treatment?
Inpatient?
Yes. No, they had you on outpatient treatment, right? And you decided that you wanted to write your own program, and your own program was not reporting to felony drug court. So here's my question to you. Why shouldn't I just send you to prison? Because you wanted help for your drug problem. I gave you help for your drug problem. It was felony drug court. They have a waiting list. You made it through that waiting list and you were actually in the program. So why shouldn't I just send you to prison? And when you answer me, I don't want to hear that I have a child, because you had a child when you've been on this probation. I don't want to hear that you need to care for your parents because your parents were here. You specifically, let's pretend like you're alone in this world. It's just you. Why shouldn't I send you to prison?
Your Honor, because I want to be able to prove to myself that I can actually get over and overcome my drug problem. And I can actually be a father to my child. and be there a productive member of society. I want to be able to become sober and stay sober. That is my main goal. To prove to the court that I can actually complete this probation and move on with my life. You know what I mean?
All right, this is what the court is going to do. The court will deny the motion, alter and amend conditions to extend for 2 years. There's to be a referral to lifetime recovery. Defendant is to be released to lifetime recovery only. There's going to be GPS. And we can do GPS tracking, waive fees, parenting classes. If they have parenting classes in-house at Lifetime Recovery, I think they may have, he can take it there. Otherwise, it's going to be compadre y compadre. And there's to be no unsupervised contact with minors until further notice. And upon release from Lifetime Recovery, I'm going to want field visits 2 times per month until further notice. Is there anything else from either side?
Judge, the only thing I would just point out to the court, and I'm not quarreling with court, but the mother of his child sometimes relies upon him to care for the child while she was working. And again, I will address that later on, but I didn't bring that up. And so he has spent a lot of time with his young child and you know, but that's something we can address later, I
All right.
suppose.
So Mr. Orta, here's the thing. I know that people think they're great parents. Nobody's a perfect parent, right? Although I think I had a perfect parent, but nobody really is a perfect parent. But when people have drugs that are clouding their mind, I can't allow them to have unsupervised contact with children. You understand? So what that means is if the mother of your child has to go somewhere, then your parents need to be there with you to watch the baby. You can't be along with the baby. Because guess what? If I'm a great babysitter and Mr. Kalfas and Mr. Villarreal give me great recommendations and say, Stephanie's an excellent babysitter, and you try me out with your child and your child loves me and you're like, Stephanie's great. And I turn back around to you because you say you're going to hire me. I say, let me tell you something. I have a drug problem. I got kicked out of felony drug court. I'm working on it. Do you allow me to babysit your children alone? Or would you want someone else there?
Probably opt out for somebody else.
That's the situation you're in now. Now, mind you, that may change, but right now, that's the situation you're in now. All right. Each day we're trying to improve. All right. Good luck to you.
That excuse, Your Honor?
Yes.
Thank you, Judge.
Who's here? All right, Norma on Castillo. Are they in custody? Castillo, your case is being reset for October 25th at the request of your attorney. Calling in order of appearance. I don't let anybody skip the line. Who's Jonathan Tate? Yes, but is he on bond? All right, can you let him know his case is being recalled? And he'll be back on the 25th. Who's here on Sky Daniels? All right, what is happening with this case?
Judge, I requested to speak with the officer sometime next week. We were just requesting a 2-week reset to allow me to do that.
All right,
don't have any objection to that, Judge.
all right, thank you. Ms. Fergus, can I have a 2-week reset on Sky Daniels?
We can come back on November 4th.
All right, we'll be back on November 3rd.
Thank you.
Welcome. Richard Gonzalez. All right, have you talked to the state about the actual case?
No, they pulled it down. We're gonna talk here in one moment.
Okay, all right. Just have a seat. Who's here on Yvette? Yvette Hernandez, this has been completed. Yeah, that's done. That's terminated satisfactorily. Who's here on Marcus Lewis? Court is calling 2021 CR 2710, State of Texas versus Marcus Lewis. Could our parties approach and announce for the record for the state? Defense? Are you Mr. Lewis? Mr. Lewis, I'm going to show you what's entitled motion to revoke community supervision and state's motion to supplement pending motion to revoke probation. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Are you the same Marcus Pierre Lewis who was placed on community supervision in 2021 CR 2710 for the offense of assault, family second offense on February 11, 2022 for a term of 6 years? Is that you? State? Do you need a copy of the? Yes, no problem. There you go.
Violated conditions. Actually, Judge. Can we step back for a second?
Yes.
We talked to, I guess he was conferring with two of us. So
Okay.
I need to make sure that.
All
we're on
right.
the same page.
Okay, no problem. Oh, no problem.
Violated condition number 4 in Bear County, Texas. The defendant Marcus Pierre Lewis did then and there fail to report to the supervision officer as directed for the months of May 2022 and June 2022 in violation condition number 4.
How do you plead to that? True or not true?
It related to the remaining allegations.
Any objections to the state's waivers?
No, Your Honor.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $1,500 fine? Did you understand? Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. Is there an agreement?
Yes, Your Honor. The agreements to deny the state's motion and alternate amendment conditions of the motion to include mixed supervision. He has previously had a mental health assessment. And so my understanding probation is already, and that's their recommendation, is ready to take with mixed supervision.
All right, is any GPS needed or no?
Based on allegations, Judge.
Okay. All right, is that the agreement, Mr. Alamon?
Yes, Your Honor.
All right. Mr. Lewis, I'm going to follow the agreement. I'm going to deny the motion, alternate amend conditions for mixed supervision. And also I'm going to ask for GPS, and we're going to do GPS for 60 days to make sure that you're reporting, okay? And so I'll ask that the fees be waived. Do you have a place to live if you're released?
Sure, for now.
Okay, so we're going to do Haven for Hope do you have any family here? Where's your family?
Houston and New Orleans.
All right, so do you want to be in Houston or New Orleans? Which place would you prefer to be? All right, so I'm going to ask for him to be considered for transfer to Houston. What is that, Travis? No, that's not Travis. Harris County. I'm sorry, I'm used to dealing with parishes. All right. So I'm going to ask for a transfer to Harris County.
For the GPS, is that passive or?
I'm sorry? Yes, tracking.
Okay.
All right. Yes, until transfer. All right, Mr. Lewis, good luck to you. When you need help, you got to reach out and ask for it. You understand? Nobody can offer you help if they don't know that you need it. All right, good luck to you.
You've been in San Antonio, Texas for over 20 years.
There's no excuses anymore.
New one.
Okay, I'm gonna come up with something else. All right, who is here for which case is this? Oh, we'll come back on our seat for this. Who's here on Kevin Lawwill? Court is calling 2021 CR 4317, State of Texas versus Kevin Lawwill. Can I have parties announced for the record for the state?
Ryan Groomer for the state of Texas.
Defense?
Tillman Schaefer for Mr. Lawwell.
Are you Kevin Lawwill?
Yes, ma'am.
Showing you a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Kevin Ray Lawwill who was placed on deferred adjudication in 2021 CR 4317 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on August 30th, 2021 for a period of 5 years? Is that you?
Yes, ma'am.
State?
Yes, Judge. Violated condition number 16, on or about the 21st day of September 2022 in Victoria County, Texas. The defendant, Kevin Ray Lawwill, did then and there fail to apply for, provide documentation of attendance, and comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or the head of or authorized personnel of the following program, a parenting class in violation of condition number 16.
How do you plead to that? True or not true?
True.
We
State.
waive the remaining conditions. Judge.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of 16, the court could find it true, grant the motion, find you guilty, not grant you community supervision, and sentence you up to 20 years in prison and up to $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of 16?
Yes, ma'am.
Court will find violation of 16 true. Is there an agreement?
We do have an agreement, Judge. We have an agreed recommendation to the court that you enter an adjudication of guilt on Mr. Lawwill's case. However, you deny the MTR and just place him on straight probation.
All right. And what are you all requesting as an underlying sentence?
Judge, I kind of told Mr. Schaefer I would defer to the court on the term, but I would say maybe somewhere in the 5 to 7 year range.
All right. So here's the question that I have. So what I see there are other things in here, but he hasn't done the parenting class. Why is there a request to convict him?
Judge, I think it's because he had, obviously there's a case, there's a new number 1 on there that we didn't go forward on today that he's dealing with in Uvalde. That was the recommendation. I'm sorry, Victoria.
Mhm.
That was the recommendation that probation had based on all of the violations that had occurred since he'd been on probation.
Okay, because I would like to still have him available for the full range of punishment, which would be 20 years if I'm going to continue him. Why should I continue you, Mr. Lawwill?
I have no excuses. I have a lot of people depend on me. They've been depending on me. It's getting serious, and I know the consequences ahead.
I mean, this has already been serious. You're on deferred adjudication.
Yes, ma'am.
So does anybody know what is his, and I'm not taking it as true, but what are these cases in Victoria?
It's a misdemeanor marijuana and a DWI first, I believe, and he's got a different counsel.
I don't have the police reports on those.
So those are the only charges?
Yes, ma'am. They're pending, sometime in December.
All right, this is what the court is going to do. Court will deny the motion, alternate mean conditions, and I'm going to extend you for 2 years. And there's to be no contact with minors until,
That he has since taken the parenting class since getting the MTR, and he's turned it into.
probation. Do you have, you knew where I was going with that.
Yes.
Probation. Has he completed the parenting classes now? Okay. All right, we're extending you for 2 years. There's to be no unsupervised contact with minors. And I'm going to keep that in place until the Victoria cases are concluded.
Or not that, or that, another. Okay. Yes.
Yes, Your Honor.
And all other conditions are to remain. So what that means with no unsupervised contact, that means that if your wife decides to go to the grocery store, and sometimes people are like, it's too complicated to put children in child seats, you need to let her know.
Okay.
You can't do that. All right, is there anything else from either side?
No, Your Honor.
All right, don't come back here again. You understand? Unless you're coming back here because you've completed everything. And recall the warrant.
Thank you.
You're welcome. Who's here on April Apolinar?
My judge.
What's happening on April Apolinar? The state, I think, was to make an offer.
Judge, we're still in the process of forwarding some mitigating information on the case. I've given him some. He's contemplating an offer, if I'm not mistaken. And he was going to make a final offer as soon as I get him 2 or 3 more documents.
And I think essentially we kind of have an offer right now. He's floated a type of counter offer that he's looking for, and he's going to provide me some of that documentation, and then I'll make it.
All right,
That
so
is correct.
I'm going to give you a 30-day reset. That's going to be the last date
I understand.
for offers to be
I
exchanged.
understand.
All right, Ms. Fergus, can I have a 30-day reset on Apolinar, please?
November 17th.
All right, we'll come back on November 17th.
Thank you, Judge.
All right, you're welcome. After you sign the reset form. Yes. Yes, Mr. Alamon?
Oh, that I was appointed to Ms. Montoya Callahan. Replacing another lawyer.
Oh, just 1 second. I'll have someone take that up for you, okay? Just have a seat. I'll get with you. All right, who's here on Hannah Smith? All right, who's here on Devon Ramirez? Mr. Alamon, just give us a moment. We're going to look into that. If you'll approach Ms. Ferguson, we'll look into that. Court is calling 2022 CR 8644, State of Texas versus Devon Ramirez. Can I have parties announced for the record for the state, for the defense?
John Sheffield, Your Honor.
And are you Devon Ramirez?
Yes, ma'am.
Counsel, have you received all the discovery in this case? Review it with your client.
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ramirez, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented? Mr. Ramirez, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ramirez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state recommends deferred adjudication. They are taken in consideration County Court Cause number 686014, 687835, grand jury number 763047. There's to be no contact with any Best Western, Markson, Markson apartments at 510 Alamento Street, San Antonio, Texas, 78212. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your
State?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 2 years. There be a TAP evaluation, 100 hours of community service restitution, and the MIC-MILF evaluation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
The intent of the offense is charged in the indictment. How do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Yes, Judge. States exhibit 1 and all attachments.
No objection, Your Honor.
Excuse me. She has a 2 on it. Because that's presiding. All right, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we just ask court all the recommendations.
All right, Mr. Ramirez, do you have any children?
No, ma'am.
All right, how far did you go in school?
11.
All right, why didn't you graduate?
I haven't went back.
Why not?
My counselor had told me that I need to go back.
All right, and which counselor? Is this the counselor for other issues?
No, for school.
Oh, okay. So who would you be living with if you were released from custody?
My sister.
All right, does your sister want you living with her?
Yes, she said that we're gonna talk about it.
Okay, so we're going to talk about it. That's not a firm yes. So if you're not allowed to live with your sister, where are you going to be staying?
With my grandma.
Does your grandmother want you living with her?
Yes, ma'am.
Have you talked to her and asked her?
I haven't talked to her, but she don't mind.
He's lived there previously.
Okay. Are you employed before you were picked up?
No, ma'am.
So how do you support yourself?
I mean, at the time I was looking for a job.
All right, so when's the last time you had employment?
Um, it's been a while.
Is there a reason that you don't have employment or you haven't had employment for a while?
No, ma'am.
So how are you supporting yourself?
I work with my dad from time to time.
So why are you not requesting to stay with your father?
My dad, I don't like to ask him for anything like that.
So you prefer to ask your grandmother,
Yes, ma'am.
but isn't your grandmother elderly?
Yeah, she's elderly.
And is she on a fixed income?
I'm not too sure.
Well, I'm sure she doesn't want to support a grown male or a grown person.
I understand.
Grandmothers at this stage in their life, the only thing they're supposed to be concerned about is spoiling their grandchildren and just enjoying their life, not taking on other mouths to feed that are adults. You understand?
I understand.
All right, I'm not letting him live with his grandmother.
Okay.
So you're gonna have to live with somebody other than your grandmother. You understand?
Yes, ma'am.
In this court, if you're an adult and you can get a job, you're gonna have to get a job. Nobody else should be supporting you. You're not a child. You understand?
Yes, ma'am.
What is your grandmother's name?
Lucy
Lucy what?
Ramirez.
All right, this is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication. Take in consideration county court cause number 686014, 687835, grand jury number 763047. No contact with any Best Western. And the Markson Apartments. There's to be proof of employment or SSI within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. MIC evaluation, and that can be done out of custody. How much time is it for in custody?
Your Honor, I'd have to check into that.
All right, if MIC evaluation is past 2 weeks, then he's to do it out of custody. If you don't follow up on your MIC evaluation, what's going to happen is a warrant will be issued for your arrest, and your MIC evaluation may take place at the Bexar County Jail. Do you understand?
Can I ask you something?
Yes.
Why did it say that some unsupervised with children or something like that?
Yes, because you have this case, there are obviously issues going on because they're asking for a MIC mouth evaluation. This is a drug case. According to the police report, you were very high when they made contact with you. So that's the type of person who should not have unsupervised contact with minors because you would not be a good babysitter.
No problem.
And if anybody were to make you a babysitter in your current condition, I would have questions about their parenting skills. You understand?
Yes, ma'am.
All right, so MIC evaluation out of custody if it's beyond 2 weeks. I'm going to want field visits 2 times per week. I'm sorry, 2 times per month, and that's until he is on the MIC caseload. There's to be no residing with Lucy Ramirez. There's to be regular reporting by Zoom or in person, and regular UAs. Probation, is there anything else that he needs?
No, Your Honor.
And I'm sorry, let's do a TAP evaluation as well and follow the TAP recommendations. If the TAP asks for inpatient treatment, just do intensive outpatient treatment. Is there anything else you need from the court? All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
No.
All right, good luck to you. I know you can do better, okay?
No problem.
All right, thank you.
Thank you, Judge.
Who's here on Jeremiah Hall? All right, this is for a PTD. All right, where are we on the PTD?
Judge, he was approved for it, and while I was gone last week, they sent me the contract. He signed the contract today, so I just have to scan an email to Beatrice. Comments and review.
All right, your client wasn't here at 9 o'clock. Why is that?
I'm not sure.
All right, who did you call? All right, so here's the thing about people calling their girlfriends and their moms and getting rides. The only person who has to be here at 9 is you. So you can't be late anymore, you understand? All right, Ms. Ferguson, I need a reset date for PTD. And they're telling me the contract has been signed. All right, we'll be back on November 17th at 9 a.m. Ms. Ferguson will give you a reset form. Make sure you're on time.
And Your Honor, my understanding is as long as the contract's in, the state might drop off, or is the state going to remain?
That date will remain unless it's dismissed.
Okay, thank you, Judge.
You're welcome. Who's here on Joshua Gonzalez? All right, Joshua Gonzalez. Good morning. So what is happening with this case?
Judge, we were asking for more time. I think that the state wants to talk to the complaining witness, and there's some discovery missing.
All right, what discovery is missing?
Specifically, one thing that I'm looking for, Judge, is a statement from my client's mother, and I haven't seen that. I didn't see that in the file.
Okay. So do we know his mother made a statement?
We think so.
Okay, so that we don't know 100%. So statement from defendant's mother. And I'll put a question mark by it. Any other discovery other than that?
No other discovery, Judge.
All right. All right, Ms. Ferguson, on Gonzalez, can I have a 30-day reset for discovery?
November 17th.
All right, we'll be back on November 17th.
Thank you, Your Honor.
You're welcome. Who's here on Richard Gonzalez? All right, can you, they have a plea on that one. Who's here on Brandon Juarez?
I am, Your Honor. We have two bargains worked out, Your Honor. Mr. Warren.
Oh, come forward, please. Let me just find him on the document. All right, Mr. Morris, why were you late today?
I'll explain, Judge. It's my fault. I was on my way to MD Anderson today for my checkup. I didn't think I was going to be here, so he was going to be reset.
Okay.
Get that resolved, and there was a miscommunication. I called and came right away. And I came in this morning, we were able to work out a plea, and it's signed and ready.
Okay. All right, look, I'd like for you, you know, it's always nice when attorneys fall on their sword, rightly so.
Yeah.
All right, court is calling 2022 CR 7316, State of Texas versus Brandon Juarez. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Edward Bartolome on behalf of Mr. Juarez. Mr. Juarez, present, ready, Your Honor, on the plea.
All right, counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I have, Your Honor, we did, Judge.
State will find that, I'm sorry, the court will find that the state is in compliance with discovery. Mr. Juarez, I'm showing you what's entitled application for application for community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're proceeding on count one of the indictment and waiving all other counts.
Any objections to the waivers?
No objections, Your Honor. We've reviewed all of the objections, Your Honor, and abandonments, and we have no objection.
Mr. Morris, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am. I do.
Did you understand in count one, you're charged with the offense of possession with intent to deliver a controlled substance, penalty group 1, 4 to 200 grams. That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am. I understand.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am. I understand.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
We do, he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Believe he is and was, Your Honor.
Mr. Juarez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain agreement. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count one. Punishment is to be assessed at 10 years in the prison. There's a $1,500 fine. State recommends community supervision. There's no application for deferred. This is run concurrent with County Court Cause number 686730. There's $285 restitution to the Bexar County Laboratory, and there is no firearm possession. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that document? I'm sorry, did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there being such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 5 years. There'll be a TAP evaluation and 150 hours community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to count one, how do you plead? Guilty, not guilty, or no contest?
No comment.
State?
Your Honor, state all the cases, either one in all actions.
No objection, Your Honor. We reviewed all documents and the video.
Mr. Warris, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, it will be no live testimony? Did you understand?
Yes.
Court will find a defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are we proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your
I
client?
support the follow plea bargain agreement, Your Honor. My client's gainfully employed. He has his own company, Judge, and he is a contractor with substantial businesses here in town. Court will notice his last, he successfully completed his last deferred, Your Honor. That was many years ago. And that's the court to place him on probation. He understands the risk, he understands the conditions, and he certainly understands and appreciates the opportunity to demonstrate and continue to demonstrate.
Yes, you need to speak up.
Sorry, Judge, start all over again.
Yes.
Thank you. I'd ask court to follow plea agreement, Your Honor. This is my
Okay,
client.
then your voice just dropped back down.
Gainfully employed, Your Honor, owns his own company. He has a longstanding contract with a substantial business here in town. He's married, has a child. And I believe he will be capable and motivated to successfully complete this probation, Your Honor. Should the court grant it, counsel long and hard concerning the issues in this case, and there are a number behind this, Your Honor, which at this point, we've discussed with the state. I believe help them to arrive where we are today.
All right. So with regards to the weapons in this case, what are happening with those weapons?
We're gonna plead those to the misdemeanor, Your Honor. I imagine they're gonna be surrendered. They were legally purchased. They are not stolen.
So state those weapons.
And Your Honor, that wasn't covered in this agreement, but that would likely be handled by the plea and misdemeanor court.
So are those weapons related to misdemeanor charges?
No, Your Honor, they're solely related to this particular case at the time of this arrest. So they would be to the felony charge, but it's a misdemeanor possession of the firearm.
It's a UCW, Your Honor.
No, that's what I'm asking. So does he have the weapons that are in this case? I understand this was a part of this drug case. My question is whether or not there is a pending misdemeanor case
There
that's
is-
related to those weapons.
There is, Your Honor, and we're prepared to go plead that, but we can't do that today. He has a court date.
Okay, because otherwise I was going to ask that those weapons be destroyed. But now that I know that there are charges related to those weapons in misdemeanor court, I won't interfere with that.
Thank you, Judge.
Yeah. Where are you employed?
I'm a contractor now. Prime construction,
License.
licensed contractor.
All right, this is what the court is going to do. Court is finding you guilty, will sentence you to 10 years in the prison, suspended and probated for 5 years. There's 150 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. Parenting classes, once you complete those parenting classes, the remaining of the hours will be waived. There's to be no firearm possession. This will run concurrent with County Court Cause number 686730. There's $285 restitution to Bear County Laboratory, $1,500 fine to be probated, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. I'm going to run a TAP evaluation. If the TAP evaluation states that he's to be in an inpatient treatment, then it will be intensive outpatient treatment. There's to be field visits 3 times per month until further notice. There's to be regular reporting by Zoom or in person. There's to be regular UAs. Probation, is there anything else that's needed? Is there anything else you need from the court in order to be successful?
He'd just like to know if he can have the return of his cell phone.
You have to discuss that with the state, but he needs to sign the,
I'm sorry, Judge, you didn't sign that.
Yes.
Secondly, Your Honor, would the court allow him to buy out his community service? He works a lot of hours.
no, once he, the only hours that should be remaining would be the COVID vaccination hours. But I will have, he must complete parenting classes.
No, I understand.
So if he completes parenting classes, then 110 hours will be waived.
Oh,
I'm sorry, 100 and,
Yeah,
what is
that'd be
he- is
correct.
it-
110, yeah.
it's
Thank you, Judge.
150 hours, right?
Right.
Yeah,
total.
110 hours will be waived.
Thank you, Your Honor.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand, Ed? And
Thank you,
because this
Judge.
is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Understood, ma'am.
All right, good luck to you.
Thank you, ma'am.
Thank you, Judge. May we be excused, Your Honor?
Yes, after probation goes over conditions.
Thank you.
All right, who's here on Joshua? Who's the attorney on Joshua Hernandez? All right, I'm talking to myself. That goes to the bottom of the pile. All right, who's here on Jennifer Tagle? All right, the court is calling 2022 CR 7737A, State of Texas versus Jennifer Tagle or Tagle, could you please approach and could parties announce for the record for the state,
Daniel Escobar for the state of Texas.
for the defense?
Robert Gaona for the defendant, Jennifer Tagle.
And are you Miss Tagle? Why were you late for court today?
I was running late on the bus.
All right, you got to take an earlier bus. I used to take the bus. I would end up at court for work at like 7 a.m. It's dark at that time. All right, counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, I have, Judge.
Court will find that the state is in compliance with discovery. Ms. Tagle, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
This one.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
This one.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're proceeding on count one and waiving count two.
Any objection?
No objection, Your Honor.
Mr. Tagle, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand that the state is proceeding on count one, which is credit debit card abuse? That's as a state jail felony. The ranges of punishment are anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You're gonna have to speak up. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, I do.
Ms. Tagle, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 1 year in the state jail facility. It says here there is no application for deferred adjudication.
It's an application for regular probation, Judge.
Okay. There's no application for deferred adjudication. The state recommends community supervision. There's to be restitution to Austin Galan, Galan, if any. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 3 years. There be 120 hours community service restitution, no contact with Austin Galan and cats 1 and 2. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, no contest. State, any evidence?
State offers state exhibit 1 in all attachments.
No
Any objection?
objections, Your Honor.
Ms. Tagle, I'm showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept any evidence states exhibits 1 in attachments. The court has reviewed the same. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, it asks that you follow her plea bargain agreement with the state.
All right. And you do understand your sister was just before me blaming this entire thing on you. You understand that?
Your Honor, I think it was her co-defendant, Sarah Laura.
Yes, saying that she was her twin sister and it was her twin sister.
I actually think she actually does have a twin sister.
I do have.
No. That's what I'm saying. The person who came in said it was the twin sister. Yes. And her name, I believe, is Sarah Laura. Yes. All right. So you can unfold your hands. Why are you taking things that don't belong to you?
Take me. I don't know. Wasn't thinking at the moment of this.
What do you mean you're not thinking at the moment? It takes thought to take somebody's stuff and then go to Walmart, Malone Grocery, the Family Dollar, and I don't know what you're buying for $175.88 from Family Dollar when I think everything's supposed to be $1, a little bit over $1. And then there's more Walmart trips, there's Shell gas station, there's an Uber, there's public storage. So how would you like if somebody were to take something that belongs to you and go on a spending spree? Do you have a job?
Right now, yes, I do.
What do you do?
Transportation, the state
What?
transportation.
What does that mean?
Medicaid transportation,
She
Okay.
drives a Medicaid van?
Mhm.
Is that what it-
No, she's not gonna be, you're not gonna be driving a Medicaid van because driving a Medicaid van suggests to me that you're driving people. Am I right about that?
Mhm.
That's either yes or no.
Yes, ma'am.
So that means that you're driving vulnerable people who may have credit cards and may have things that you can have access to. So I'm not allowing that. You understand? So you're gonna have to get another job.
Yes, ma'am.
I don't allow people on probation out of this court to be at home healthcare providers, to work with minors, to be in any type of occupation where they're around vulnerable people. So, I mean, you can get a job in construction, you can do that, but you will not be driving a Medicare van. So this is what the court will, do you have any children?
One,
Age?
7.
Okay. Live with you?
No,
Why not?
those are my mom and dad.
So that means that there's somebody else taking care of your child. Are you paying child support?
Yes, I am.
How much?
120 every 2 weeks.
Is Child Protective Services involved?
No, ma'am. The
The-
case is closed.
All right, so that tells me that you didn't do what you needed to do, otherwise you'd have your child. There's going to be $1,000 fine probated. As previously stated, the court is finding you guilty. There's to be restitution and no contact with Austin Galan. Proof of employment within 30 days. Probation. She is not to be driving a Medicaid van or working with any vulnerable people. And there's to be no employment as a home healthcare provider or with minors. And you can give them you're going to give your employer your 2-week notice, so they won't be left in the lurch. So you're going to give them a 2-week notice. And after those 2 weeks are up, you're not allowed to work there anymore. 1 year in the state jail facility, suspended and probated for 3 years, 120 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. You are going to complete parenting classes. I guess you didn't complete them for CBS, but you'll be completing them here. So there's to be parenting classes. Once she's done that, the remaining community service hours will be waived. There's going to be CATs 1 and 2. There's to be regular reporting by Zoom or in person. There's to be field visits 1 time per month. There's to be no unsupervised contact with minors. And there's to be regular UAs. And if you're drug tested today, what are the results going to be?
30.
For what?
For weed.
All right. And so you are driving and you smoke. That's a problem.
I already gave her my 2 weeks notice.
Okay, great. So you're just hopping from job to job. All right, I'm gonna want her to do the UA hotline. And she's to be tested at least every 2 weeks until she's clean. And then there will be sober meetings. Probation, is there anything else she needs? Is there anything else you need from the court? I'm gonna show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Probation will go over conditions.
Thank you, Judge.
You're welcome. All right, who's here on Hannah Smith? Yes, what is happening with Miss Smith?
Appointing expert.
Yes.
Now that expert wants me to get a couple of other people to help me assess other components of this case. So I'm currently looking for people that are willing to work for court-appointed money. Because apparently these guys get paid a lot more money than court-appointed counsel.
All right, so Ms. Smith, come over. All right, Ms. Ferguson, can I have a 30-day reset?
November 17th.
All right, so we're gonna come back on November 17th, and hopefully you will have some expert.
Okay. She just popped that out like easy.
Oh, that's where everyone's November 17th.
Okay, all right, she practiced.
All right, okay, thank you.
Now they excuse your honor.
Yes.
Thank you.
Hannah can go back. Who's here on Raul Reyes?
I am yours.
He's waiting for you.
All right, where's Raul Reyes? Come forward. Oh, you are not off somewhere hiking?
No, thank God.
Yeah. All right, what is happening with this case?
So Judge, while I was on vacation a couple of weeks ago, the DA's office uploaded something like 30 recordings that I have not been able, that I just found out today.
Okay. All right, Ms. First, can I have a 30-day reset on Mr. Reyes for discovery?
Thank you.
All right, we'll be back on November 15th for discovery.
Thank you, Judge.
All right, thank you. Just get a reset form from Ms. Ferguson, then you're excused. These are done. Who's here on Mariah Lopez? All right, Ms. Lopez, come down, please. All right, what is happening on this case?
Good, based on the notes of the state prosecutor, she had requested that they issue a search warrant for some social media records. I followed up with the state prosecutor today, see if there was an update on that. She reached out to the detective, but the detective has not answered back. I don't know what the status is, but there should be, hopefully, fingers crossed, a search warrant already issued and the results should be pending.
All right, Ms. Ferguson, can I have a 45-day reset on Lopez for discovery?
December 8th.
All right, we'll be back on December 8th to check with the discovery issues.
Judge, would you consider a PR bond on her?
Just ask Ms. Well, for the type of case, she's not gonna get a PR bond for an aggravated kidnapping. But if you do the evaluation, the court will hear a bond reduction.
Okay, thank you.
All right, so we'll be back on December 8th. Ms. Ferguson, on Lopez, could you have our interview for a PR bond just for the court?
Yes.
Who's here on Montoya Callahan? Where's Montoya Callahan? Thank you. Are you all ready to proceed?
I don't know what's going on, Your Honor. I have another lawyer and then all of a sudden.
Okay, who's her attorney?
He's appointed, Judge.
Yes.
I've hired James Anders. I'm not sure what's going on.
Right, James Anders hasn't filed a notice of retained counsel. Did you cut, Ms. Ferguson, were you able to cut? All right, just have a seat. We're gonna contact.
Mr. Anders was who represented me prior to.
Oh, well, you have to make sure that you have actually retained him. So Ms. Ferguson, we're gonna call him.
This is what the confusion comes in. I'm sorry, Your Honor. I had two separate cases. The second one, that's when James Anders came into the picture, and I'm not certain if whether or not he was my court-appointed attorney on this case or the
All right,
other.
so here's the thing. If you're looking for a court-appointed attorney, this is your court-appointed attorney. If you're saying you hired an attorney and it's Mr. Anderson, he has not filed a notice of retained counsel.
Well, that's.
Judge, I'm sorry, Mr. Anders no longer works for the, he's no longer in the wheel.
Yeah.
And he's no longer here.
So this is your court-appointed attorney.
Okay, so that's where I need to get the clarification because I'm confused.
Okay, all right. So
Okay.
if you'll discuss things with her, please, Mr. Alomar.
And I have a question. I did not receive the appointment. I don't know why, it was a mistake or something.
All right, do you mind discussing with her today?
I would like to, a 7-day recess, and I will speak to Ms. Callahan on Saturday by Zoom at the jail.
All right, I'll give you a reset, but the state is here now, you're here now. So if you can let her know what's going on with her case, the court would appreciate it.
I can't explain to her what they want to do.
Well, I mean, she's here. Yes,
Yes, I just don't. I get him telling me this is what they're offering you. I haven't even spoken to this man before. I
Well,
haven't even
here's the
been able to
thing.
explain my situation to
all right,
him.
so this is where we are. I'm gonna give him a reset. He says he wants to come and visit you on Saturday. But I want to make sure that he has everything that he needs. So the conversation you have with him on Saturday will be a fruitful one. So nothing's gonna happen today. Okay, not until you've seen everything, all right? So trust me, I always want to make sure that the defense and the state and the defendants who are here know everything that's happening with their case. Okay? All right, so Ms. Ferguson,
They're giving me an offer and I discussed it with the judge at the police.
well, no, we're gonna give you your 7-day reset. What date can we bring this at?
We can come back on the 31st.
All right, so we're gonna come back on October 31st, okay? And we'll see where we are then.
Okay.
And then if there are any issues, the court will take it up at that time. You're welcome. All right, Norma on Chavez, I see there's a reset from defense attorney.
He's asking for it to come back on that.
Okay, is there a reason for that? I mean, I'll do it, but what's the reason? And that's for, well, see, I have one that says recall for tomorrow or Monday.
On top of it, it says, right, Marion.
Mhm.
He received it on Monday, which we just didn't have it on.
Okay, so recall both of these cases then for the 24th.
For the, yeah, for Monday, the 24th.
Okay.
It's just Travis's case.
Well, there's two. Nathan Chavez, he has two cases.
Yeah, Travis actually failed.
Okay.
She's also the victim in the case she does. She's a huge crocheter.
All right, thank you. All right, who is here on Joshua Hernandez? All right, court is calling 2022 CR 8048, State of Texas versus Joshua Hernandez. Joshua Daniel Hernandez, where are you? On Joshua Hen.
Is there a sticky on it?
No.
Is that without me to come in tomorrow or Monday?
All right, let's call it back on Monday. Is Mr. Osterstorff okay? These are done. They're all done.
Okay.
Who's here on Richard Gonzalez? Court is calling 2022 CR 9493, State of Texas versus Richard Gonzalez. Could I have parties announced for the record for the state, for the defense? Are you Richard Gonzalez?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Next, I'm showing you what's entitled Application of Community Supervision. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes, Your Honor, I did.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor, I did.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Gonzalez, I'm showing you what is entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I did, Your Honor.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor, I did.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor, I did.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor, I did.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor, I did.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor, I did.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
My opinion, yes.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor, they have not.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am. No, Your Honor, they have not.
Are you satisfied with the way you've been represented?
Yes, Your Honor, I am.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor, I did.
According to the plea bargain agreement, punishment is to be assessed at 1 year in the state jail facility. There's $1,000 fine. State recommends community supervision. They will take in consideration county court cause number 694367. And there's $57 restitution to the Bexar County Laboratory for testing. Did you understand that to be the plea?
Yes, Your Honor, I did.
Defense, is that the plea?
It is.
State, is that the plea?
It is, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney?
Yes,
Did
I
you understand it? And did you sign it in both places?
Yes, I did, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am. Yes,
Counsel,
Your
have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation, 120 hours of community service restitution, and a felony drug court evaluation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor, I did.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State offers instance of one in all attachments.
Yeah, I reviewed these, my client with no objection.
Mr. Gonzalez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor, I did.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor, I did.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court is finding there is sufficient evidence to find you guilty, and the court is finding you guilty. Are you proceeding with sentencing?
We'd like to, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, spoke to my client. He's asked that you follow the plea bargain, grant him a 2-year probation in this case.
All right, is there gang issues here? Because
No.
if he's a gang member, they will not accept him in felony drug court.
Not, I'm not affiliated with no gang, man.
Is that just current or has there been a documentation in the past?
I have not been affiliated with gangs since high school.
All right, so there is documentation out there somewhere. So felony drug court, because they have limited placement, they're not going to accept him. So where would you be living if you're released?
The address where I provided on the
Who
paperwork.
lives there with you?
My 2 sons and their mom,
How old are your children?
18 and 19 and 17 and 19.
And when's the last time you had employment?
Last time I was employed was about 4 or 5 years ago. I received social
For what?
for I had hurt my back and I received social security every month for about 3 years, 4 years. No more than that, about 5 years, 6 years.
So what do you do in your spare time?
I'm just there at the house.
Well, I mean, this incident didn't
walking
occur at your
around.
house.
I was homeless for a while until they recently allowed me to go back.
All right. All right, this is what the court is going to do. The court is going to sentence you to 1 year in the state jail facility, suspended and probated for 2 years. What is your wife's name?
I'm not married.
Well, who is the mother of your children? What is her name?
Esmeralda Garcia.
I'm sorry, what?
Esmeralda Garcia. I'm not affiliated with any gang members or anything like that, man.
Okay. There's $1,000 fine. That'll be probated. Take in consideration county court cause number 694-367. There's $57 restitution for testing. And probation, he insists he's not a gang member, so we can do a referral to felony drug court. If not accepted, then we're going to do a TAP evaluation. And I want that TAP evaluation done while he's in custody and to follow the TAP recommendations. Of course, if TAP is recommending inpatient treatment, we'll start with intensive outpatient treatment. I'm going to want field visits 1 time per month. And there's to be no contact with his current living situation, Esmeralda Garcia. And I will look into that and maybe change it, but he needs to be sober. Show me some sober months and then you can perhaps go there.
I did probation term in 2001 and in 2003, and I did complete that successfully and all that. If that's in, just letting you know that the view in the courtroom, Your Honor.
All right, I understand that, but here's the thing, it seems like you do well when somebody's supervising you, but I can't supervise you for your entire life.
Oh, that's of course that,
All right, there's a regular reporting by Zoom or in person. We're going to do the UA hotline.
Where's that?
That's going to be where you call in to receive a drug test. And I want him tested at least once a week. There's 120 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to do that, but if you do, 40 hours will be waived. There's going to be proof of employment or SSI within 40 days. There should be no employment as a home health care provider or with minors. Is there anything else that he needs, probation?
No, Your Honor.
Is there anything else you need from the court in order to be successful?
No, everything seems fine, Your Honor.
All right, and I'm sorry, probation. Also, there should be no unsupervised contact with minors.
And Judge, if the court knows, how long of the TAP evaluation?
Oh, they usually have it ready in about a week. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, ma'am. Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. You
Yes, sir.
understand?
Yes, sir.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney.
That's fine, Your Honor.
All right, good luck to you. Do better. Your sons are looking up to you. Be a good example, okay?
Yes, Your Honor, I will. Thank
All
you.
right, you're
Sure.
welcome.
Just house cleaning, we initially started this because of the violation report. I don't know whether you took any.
They never
action
put
on
that in the system.
Okay.
All right, thank you.
Thank you, Your Honor.
That's correct, right? You didn't put his violation in the system? Okay. All right, the court is calling 2022 CR 8212, State of Texas versus Clint Johnson. Thank you. If I could have parties approach and announce for the record for the state, for the defense.
Disobeying for Mr. Johnson.
And are you Mr. Johnson? Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Johnson, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Waiving the repeat.
That's correct, Judge. We're waiving the repeater. and repeater.
Any objection?
No objection. No objection. I'm so sorry.
All right, Mr. Johnson, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
I did.
Did you understand you're charged with violation, sex offender registration as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes. Yes.
All right. Why don't you put your glasses in your underwear as opposed to in your pocket?
No, they're, this part here, they ride it up.
Okay.
and on, they fall out.
All right. That offense carries a sentence from 2 to 10 years and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
I did. ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
I did. ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes,
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
I did. ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, yes.
Mr. Johnson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No.
Are you satisfied with the way you've been represented?
I am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
I did.
According to the plea bargain agreement, punishment is to be assessed at 2 years in the prison. There's a $1,500 fine, no applications, and Chapter 62 compliance. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Judge.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Judge, the offer was been marked as state exhibit 1.
We've reviewed State Exhibit 1 with our client, Your Honor. We have no objections.
Mr. Johnson, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document
I
with
did.
your attorney? Did you understand it? Did you sign it in all the appropriate places?
I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Nothing further, Your Honor.
All right, then the court will follow your agreement, sentence you to 2 years in the prison, give you credit for any time served. There's a $1,500 fine. Time and money will run concurrent. And Chapter 62 compliance. All right, I'm going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
I did, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney, okay?
Yes,
All right, don't let your glasses fall.
ma'am. I won't. ma'am.
All right, good luck to you. Here's the thing, we're off the record. You got to report. And if you don't report, what's going to end up happening, you're going to be before another judge or somebody else, and that repeater paragraph is not getting waived. So if you want to live somewhere, the rules are you got to tell people where you're living, you got to register it. And if somebody doesn't want you living at their house and registering it, then maybe that's not a relationship you should be in. You understand?
Yes.
All right, good luck to you. Who's here on Gregory Gonzalez? Where are we on this case?
Judge, we're in the process of reviewing discovery. I converted with the DA this morning or shortly ago, and she conveyed an offer, so I need my client to.
Okay, wasn't, because I showed that an offer had already been conveyed on September 22nd. Was there a new offer?
No, Judge, but I do think that it is a relatively new case with our office.
And where is Mr. Gonzalez?
He's in the very back.
Gregory Gonzalez, come forward. Ms. Ferguson, give them a 30-day reset for a plea deadline date. Court will not extend plea deadline date again. What date, Ms. Ferguson?
And Judge, just so the court's aware, this is our first setting with Mr. Gonzalez. He may have had a prior attorney.
He did. All right, Ms. Ferguson. All right, November 15th is your plea deadline date. The court will not accept any plea bargain agreements after that date. If you wish to enter a plea, you'll have to do so open to the court, and the court will only accept a plea bargain agreement with good cause after that date. Do you understand, Mr. Gonzalez? All right, thank you.
Thank you, Judge.
You're welcome. Who's here on Robert Chevalier? All right, if you come forward, please. Thank you. Court is calling 2020 CR 3796, State of Texas versus Robert Chevalier. Could I have parties announced for the record for the state?
Michael Villarreal, State.
Defense?
Ronald Menard for defense.
Are you Mr. Chevalier?
Yes, ma'am.
Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Chevalier, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state's proceeding on the lesser included offense of aggravated sexual assault of a child. And we're waiting and abandoning the repeat offender allegation.
Any objection?
No objections, Your Honor.
Mr. Chevalier, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, sir.
Did you understand that the state is proceeding on the offense of aggravated sexual assault of a child? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to $10,000 fine. Did you understand?
Yes, sir.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, sir.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, sir.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, sir.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to life in prison and up to a $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Chevalier, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, sir.
According to the plea bargain agreement, state is proceeding on the lesser included offense of aggravated sexual assault of a child. Punishment is to be assessed at a cap of 15 years in the prison. There's a $1,500 fine. State is remaining silent on your application. There's to be no contact with the child victims and their families in Chapter 62 registration. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
They're not, Your Honor.
To the lesser included offense of aggravated sexual assault of a child, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, sir. At the time, state upper state exhibit number 1 and attachments.
No objection, Your Honor.
Mr. Chevalier, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. When are we coming back for sentencing?
We can do December 12th.
All right, we're going to come back on December 12th. Probation, I need a PSI report. And we will be back at 9 a.m. And the court will make a decision on your application based upon the report that I receive and any other evidence that's submitted. Do you understand?
Yes, ma'am.
All right, Ms. Ferguson will give you a reset form and probation will tell you what you need to do.
Thank you, Your Honor.
You're welcome. Court is calling 2022 CR 4998, State of Texas versus Manuel de la O. Could I have parties approach and announce for the record for the state,
Caller for the state.
for the defense?
Alberto Acevedo III for Mr. Delo.
I'm sorry, I didn't understand.
Alberto Acevedo III for Mr. Delo.
In probation, there's no application on this case.
Thank you.
Are you Mr. Delio?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case? And did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Della O, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we're proceeding only on count one and waiving count two, also waiving the repeater.
No objection, Your Honor.
Mr. Dello, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with assault family second offense? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement with, in this case? Counsel, has your client been able to provide you with any defenses?
That's right.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. DeLeo, has anyone threatened you, coerced you, or placed you in fear to get you in this plea?
No.
Has anyone promised you anything other than the plea bargain agreement?
No.
Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you what's entitled plea bargain page. Did you review that page with your attorney? Did you understand it? According to the plea bargain agreement, states proceeding on count one, punishment is to be assessed at 4 years in the prison. There's a $1,500 fine, no applications, no contact with Melinda Longoria, affirmative finding of family violence. State will take in consideration County Court Cause number 686098, grand jury number 770045. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Your Honor.
Did you understand with the affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand? Then to count one in the indictment, how do you plead? Guilty, not guilty, or no contest? All right, off the record. Would you mute us, please? All right. Is there a motion from the state?
Yes, Judge. We move to amend the indictment to read Melinda Ruiz Longoria.
All right, any objection, defense?
No objection, Your Honor.
All right, and Mr. Delio, you understand that's a substantive change to an indictment. Do you have any objection to going forward with that amendment? I'm sorry.
Oh, no.
All right. Then state the defendant has entered a plea of no contest. Do you have any evidence to support the defendant's plea?
Yes, Judge. We would offer what's been marked as State's Exhibit 1.
Any objection?
No objection, Your Honor.
All right, Mr. Dillon, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand? Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept that into evidence. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing? The court will follow your agreement, sentence you to 4 years in the prison. There's a $1,500 fine, time and money to run concurrent. Take in consideration county court cause number 6866098, grand jury number 770045. There's to be no contact with Melinda Longoria or Melinda Ruiz or Melinda Ruiz Longoria. There's an affirmative finding of family violence. And the court will give you credit for any time served. Is there anything else from either side with regards to sentencing?
Nothing from the defense, Joe.
Mr. Dello, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, good luck to you. We can go off the record. You're gonna have to start making better decisions in your life. Otherwise, you're gonna find yourself living at the Bexar County Jail or someone else's jail or in the prison. When somebody moves along with their life, they're moved along. All right, good luck. Court is calling 2022 CR 7683, State of Texas versus Antoine Land. Could I have parties? You going over documents? All right, to the court reporter. All right. Do you need a break? Okay, we're gonna take a break. Court reporter needs a break. Hey, whenever you need a break, just do this. Okay. All right, we're gonna take a short break.
If you have paperwork on Michael, last name is Munoz. Michael Young, Munoz.
I'm asking that we reinstate her bond. She had a court-appointed attorney that
Okay, I don't have the file.
I'm gonna try to go watch them earlier. I can get over there. Crazy tomorrow.
Just tell him to leave it here and come back this afternoon. I'll look over it. Yeah. thank
Is that
you.
what it is?
All right, what is here on RC Curtis?
I am. Yeah, approach.
Yes.
Today was the day that the briefs were due, but Brenna just got us the stuff like Tuesday, the transcript. So can we get an additional week for the briefs to be due till next Thursday and then have the arguments the Monday after that? I've talked to Mr. Maury with the state. He's okay with that as well, because he's still working on his, and Dana would like some more time since we just got the transcript.
Okay, Ms. Ferguson. Mr. Curtis, can you put these briefs, whether briefs are to do on Thursday the 3rd? And can you give me another date for a Monday for them to do their argument as opposed to October 24th?
That's far out.
Yeah, that's too far out.
November 7th?
Yes, November 7th.
That should be fine. So briefs due on the 3rd, arguments on the 7th.
Yes,
Got it. I'm letting everyone know. Thank you.
you're welcome.
They can in the file, Judge. From the legal department, they can in the file now.
Okay. All right, go get in your file. Yes. All right, Deputy Laura and Norma. Yes, Mr. Can we go on? Are you moving? And do some video. It's on Antoine Lynn.
Yes, sir.
Judge, I'm gonna,
Yes.
I'm gonna leave.
She has to go.
Okay. Yeah. But hey, I hope you enjoyed your time here.
I'll remain silent. I will remain silent.
Do we need to get an attorney appointed to represent you? Thank you so much.
Maybe workman's comp.
All right, but you know what, Brenna?
I owe you.
Brenda, her being here is gonna make you be even treated better than before, if that's possible.
Oh, okay, no problem.
All right, court is calling 2000. Oh, sorry.
Judge, you're too quick for everybody.
Brenda, maybe, I don't know if people are gonna want to substitute for you after that.
Well, I don't think so, Judge.
You know, she didn't tell me she needed a break, so we were just.
She called Maria. Maria called.
Oh, wow. All right, the court is calling 2022 CR 7683, State of Texas versus Antoine Lynn. Can I have parties announced for the record for the state? Defense?
Good morning.
And are you Mr. Lynn? I'm sorry? Yes, and is your name Mr. Lynn?
Yes.
All right. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery and did you review it with your clients?
I have.
Court will find that the state is in compliance with discovery. Mr. Lynn, I'm showing you application for deferred adjudication. Did you review that with your attorney? Did you understand it? Next, I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
All right, Mr. Lynn, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with unauthorized use of a vehicle at the state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, court doesn't have to follow your plea bargain agreement. If for any reason the court doesn't follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to do that and enter into a plea bargain agreement in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty and sentence you up to 2 years in the state jail facility?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He has, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Lynn, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargain agreement? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, there's to be $1,000 fine probated. State recommends deferred adjudication. This is run concurrent with County Court Cause number 613390. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 2 years. There be a TAP evaluation, 100 hours of community service restitution, and no contact with Juan Avila. Did you understand that to be the state's recommendations, but the court does not have to follow those recommendations? Did you understand? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Judge. State Exhibit 1 and all attachments.
No objection.
Mr. Lynn, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court is finding there's sufficient evidence to find you guilty. Court is deferring finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
None at this time, Judge.
All right, Mr. Lynn, when's the last time you were employed
In May,
and what were you doing?
I worked at Popeyes, cooked chicken.
Okay. And do you have any family here?
No,
Where's your family?
my wife left me and went to move to Florida.
Okay. And so that's your only family you have, your wife?
Yes,
Do you have any children?
I had 7 kids.
All right. And how old are they?
10, 13. It's like I'll get through that.
Okay.
I can't
'Cause
decide.
all right, because you gave me 2. I'm not being hard. I'm not asking you for their birth dates. Should I do that? Okay.
I remember.
All right. So where would you be living if you're released from custody?
I'm rent to I got a house on Converse with my homeboy.
Who's your homeboy?
Some boy I used to work with at a job, some staff job, so I rent out a room.
Okay. All right. Is there any drug issues here?
Not that I know, Judge.
Okay. So have you ever used drugs? All right. Any mental health issues?
So she was reviewed for sanity and competency and found to be not insane and competent, Judge.
Okay. Okay. That's the double negative you're doing, not insane. So I'm like, okay, sane.
He was found insane
Okay,
at the
all
time
right.
of the offense, and he was found competent, Judge.
All right, thank you. This is what the court is going to do. 2 years deferred adjudication, $1,000 fine, probated, concurrent with 613390. No contact with Juan Avila, 100 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. There's to be regular reporting by Zoom or in person to probation. There's to be regular UAs. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. field visits one time per month for 3 months. And if there are no issues, then the field visits can be as seen appropriate by probation. All right, probation, is there anything else he needs? Mr. Lynn, is there anything else you need from the court in order to be successful? All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, good luck to you. Do better. All right, okay, yes.
Yeah.
All right, who's here on Chelsea Warren? All right, where is Chelsea Warren? All right, what is happening with this case?
Judge, there's a co-defendant, Robert Porter was on it earlier. We've gotten some warrants that we were asking about that are significant in the case today. And I said it, I believe he said it for the 17th for discovery review.
All right, Ms. Ferguson, what day is Porter's client set on?
November 17th.
And Judge, I'm gonna be out of town that day. Can I get the following week? That's the Thanksgiving week, but following week, but like on Monday, just, 'cause I'm not gonna be in town on that 17th. You said that before I got here.
All right, so I like to keep these cases together. I know you won't be here. We'll put a notation in the file that you're not going to be here, but she will be here on the 17th, and then we'll see how the other case is and what date it's
Yeah,
on.
well, and that would be fine, because Mr.
Yes.
Porter and I are working on it together, so
Okay,
I can talk to him ahead of time and he can kind of speak for me, because the
yes.
defenses are the same.
All right, so we'll come back on November 17th. I know that I'm putting a notation in the file that your attorney won't be here, and we'll see where we are with discovery.
Thank you.
Thank you. And thanks for being on time. I see you took my talk to heart.
We got here early, actually.
All right, Karen Munoz. All right, so the question on this. The knife sign hasn't been signed. So. Lucky for your client that it wasn't signed.
What?
I said the knife sign hasn't been signed, so that's lucky for your client.
That's true.
All right, so he's saying that his client didn't receive notice of the setting.
I
Yeah.
am told that by her mother, who hired me this morning.
Okay, but what I can tell you is the notice of setting would have been sent out by the system to her address. Okay. So this is what we're gonna do. Ms. Ferguson,
She was on PR bond before.
okay. On Ms. Munoz. Can we bring her back on Monday? Or no? Okay, let's bring her back on Tuesday. I'm not gonna sign the knife sign, and because I need to find out what was going on with her. So we'll come back on October 25th.
Done.
All right, thank you.
Yes, sir.
All right.
All
We can copy it, but I don't know.
All right, thank you. All right, everyone, we are on our break.
You got my number?
You need a break.
Oh, yeah. No. All right, everyone, we're on break. Unless people want to go another 2 hours.
No, Judge.
No,
I think you need a break.
I do.
What time y'all coming back?
1:30.
Are y'all still in trial?
Yes, we're in jury trial.